researcher. He has written grounding papers, grounding books in the areas of expertise. He has developed a handbook for judges on human rights and African abortion laws. He has recently collaborated with Afiana Haki to develop a paper on decolonizing SRHR, laying foundation for an Afrocentric, African-centered approach. The publication is on the website of Afiana Haki. I cannot say much because there's a lot to say about Professor Ngwena. I can say for the entire day. Allow me to invite him to make the presentation. He's already waiting for us. He's attending virtually. He's ready for us, and we're also ready for him. After that, we'll have a panel discussion. Join me in welcoming Professor Ngwena.
I think I'm disabled. No, it's fine now. Can you hear me? Are you able to hear me?
Me, I can hear you.
Can you hear me?
Me, I can hear you.
What about the other?
So we are ready to listen to you.
Okay, you can hear me.
Yes.
Can you also assist with the slides, please?
Okay.
And I'll indicate as I proceed.
I think you can proceed as we project them.
All right. Let me begin with the first substantive slide. And before that, let me thank Afnan Naihaki for the immense privilege of inviting me to participate in this important gathering. I'm ever so grateful, and my task is made easier because the speakers before me were able to deep into the issues with immense knowledge and depth, and it leaves me with very little to add. So I'm very humbled that I'm coming at a time that much of the work has already been done, but I hope I'll be able to add some value. I begin with my first substantive slide titled The Fierce Urgency of Maternal Mortality for Sub-Saharan Africa. My paper focuses on how we can use litigation in order to address maternal mortality. And my first observation is do with what Martin Luther King Jr. would have described as the fierce urgency of now, when he was highlighting the plight of the oppression of Black people in the United States. If we juxtapose that phrase to maternal mortality, and if we zoom down on the global South, and more pertinently on sub-Saharan Africa, we will be confronted with very depressing but also very shocking statistics. And this is by way of repetition, but I think it's important that I highlight that maternal death remains a challenge, even if progress has been made in the last 2 decades or so to reduce maternal mortality. It remains a formidable challenge. Almost 95% of all maternal deaths occur in low and lower middle income countries. So this immediately highlights global inequities in not just access to healthcare services, but global inequities in standards of living. And I would like to emphasize that as we think about maternal mortality, we should always be thinking about poverty, because it is the major explanatory factor in the occurrence or persistence of maternal mortality. Sub-Saharan Africa itself, on its own, accounts for roughly 2/3 of maternal deaths. And if you're to ask comparatively, what is the lifetime risk of a person or a woman in Africa dying from pregnancy-related cause, it's 1 in 37 in sub-Saharan Africa, compared to 1 in 4,500 in high-income countries. So the disparity is very stark, and it's one that cannot be sustained. It is one that calls for urgent action on part not just of the African states, but also the global community itself. Maternal mortality is well understood medically. It is understood that the major causes of maternal mortality are severe bleeding, high blood pressure, pregnancy-related infections, complications of unsafe abortion, and underlying conditions. And we know that COVID compounded maternal mortality because many women were unable to access the care they needed. So let me move to the next slide, please. So what are my objectives today? Partly, I'll be speaking to you about concepts that have been spoken about by previous speakers. But in this instance, I would like to apply a reproductive justice framework to litigating maternal mortality. That's one of the objectives. And the second objective is to locate a reproductive justice framework within a rights-based framework. And thirdly, in tune with the focus of the meeting, I would like to be able to apply a decolonial framework with a view to transforming African healthcare systems as they were founded during the era of colonialism to independence and the post-independence period, if there is such a period at all. Let me move to the next slide, which is that in order for me to apply the reproductive justice model to maternal mortality, it is important to unpack it. It is important to explain what it is in order to see what addition it makes to our contemporary understanding of how we can use human rights to render the state accountable for the death of women as a result of pregnancy. We can say reproductive justice is a current framework for activism and for thinking about the experience of reproduction. We can say it is a political movement that splices reproductive rights with social justice to achieve reproductive justice. And the addition of social justice is very crucial to the understanding of reproductive rights, only because historically that element tended to be neglected. In other words, the notion of reproductive justice goes beyond mere choosing. It's not about choice only, but it's also about capabilities to choose. Choice is only meaningful if it is supported by means, if it is supported by resources. So if we are unpacking the concept of reproductive justice, we can say it has three primary principles, one of which is the right not to have a child. The second one is where my focus is today, is the right to have a child. And the third component is the right to parent children in safe and healthy environments. And I'll speak later on about what ought to accompany reproductive justice in order to achieve its goals. So we have these three core principles, but we should also try and remind ourselves how they came to be. And I know this might be tedious for you because speakers before me have given us a history of the emergence of the concept, but it is well remembering that the concept came from a social group that was experiencing oppression and invisibility. Those two concepts are important to understand the rationale of reproductive justice. When people are oppressed, it means they can not attain their personhood. They cannot live the life they desire. If people are marginalized and invisibilized, it means that their grievances cannot be heard. So there was a real sense that the manner in which white feminism in the global north had developed the concept of reproductive rights made it difficult to hear the grievances of Black women, Hispanic women, migrant women, lesbian women, all those groups that are marginalized by dominant narratives. So that is the context in which the concept arose. It began as a movement designed primarily to protect women's rights to choose reproductive health services, but it broadened into a comprehensive right that addresses the full experience of choosing about reproduction. So we can move on to the next slide. It's also important to remind ourselves that these concepts of reproductive justice comes at the back of what we describe as eugenic thinking, the belief that only those with certain genetic profiles should be allowed to produce. And we often cite the case of Buck and Bell, a 1927 case which came before the Supreme Court of the United States. And what was at issue in Buck and Bell was forced sterilization. It was compelled sterilization, and the Supreme Court endorsed state legislation that authorized state authorities to sterilize women who were deemed not fit to be parents on account of intellectual disability. So that's a very important background because it tells us that reproductive justice is not just about choosing not to be pregnant, not to be a mother. It is also about choosing to become a mother. It is about the rights and freedoms that are implicated in reproduction. And that is why you find that if you look at the Convention on the Rights of Persons with Disabilities in Article 23 and Article 25, it highlights the importance of protecting the sexual and reproductive rights of persons with disabilities. And in Article 23, it also highlights that states have a duty not to deprive persons with disabilities with their capacity to reproduce. So that is an important observation to make as we think about how different reproductive justice is from the notion of reproductive choice. But equally important, reproductive justice was a reaction to aggressive promotion of contraceptive treatment to control the population. And in this instance, you will see a synergy between reproductive justice and the idea of reproductive rights as human rights as developed at the International Conference on Population and Development in 1994, as well as at the Beijing Conference in 1995. It was the idea of ensuring that states cannot use women as means to an end. Women have inherent dignity. They are entitled to equality and non-discrimination. They should be allowed to choose contraception if provided with the requisite information if provided with the means with which to choose contraception. Ultimately, reproductive justice seeks to address the historical exclusion of certain categories of social groups from access to health care on the basis of associational categories such as poverty, gender, gender identity, age, race, ethnicity, disability, sexual orientation, nationality, and immigration status. We can summarize these associational categories as coming under the axis of intersectionality. Intersectionality tells us that society is stratified. People, social groups come under interlocking layers of oppression, and they will experience them differently according to their social positions. Intersectionality also tells us that people have multiple identities. Women are not just women. They may be elderly or they may be young. They may be heterosexual or they may be lesbian. They may be of a particular race, a particular ethnicity. They may have a disability. They may have a certain nationality, or they may be immigrants. And all these criteria renders them vulnerable to exclusion and marginalization from access to healthcare in particular locations. Some will come with advantages, but others will come with disadvantages. So I'd like to emphasize on the next slide on activism behind the concept, because it is all very well for us to talk about the normative content of reproductive justice. Yes, we can recite that reproductive justice is the right not to have a child. It is the right to have a child. It is the right to bring up a child in a healthy environment. But equally important is how we give life. How do we keep that mantra alive? We do so by identifying those stakeholders who have a duty to address reproductive justice. And the state is a major stakeholder because it has monopoly over organization of healthcare services. We have a social contract with the state. We become citizens, and in return, the state enters into certain obligations. If we look at our bills of rights, that's what the bills of rights are really telling us. They are telling us that the state has certain obligations. And increasingly, we know that the right to health has become visible in international bills of rights. They've become visible in national bills of rights. But how do we give flesh to that? How do we ensure that the state performs its side of the bargain. It collects taxes from us, but how can we ensure that it is also delivering on provision of healthcare? Civil society plays an extremely important role in ensuring that the state is constantly reminded of its obligations to deliver on reproductive justice. And we do so by organizing ourselves as women, by also organizing ourselves as coalitions, by joining our cause with the cause of others that have been excluded from protection, that have been marginalized by dominant narratives of state care. We do so in order to build a coalition of social justice movements. And it's not accidental that when you look at strategic litigation, you will always find behind it is organization by civil society. Behind strategic litigation is a movement. And that movement is important before the litigation as well as after the litigation to ensure that strategic litigation does not end in the courtroom, but it also has an afterlife after the courtroom. The next slide, please. So one of the questions we can ask ourselves is this: is reproductive justice something different from international human rights? I would like to suggest that no, it is not something different, but what reproductive justice does is to enrich how we think about human rights. It is not taking us away from a rights-based approach, but it is reinforcing a rights-based approach in order to ensure that a rights-based approach does not leave out social justice. It does not think about rights in abstract, but imagine rights in our society. So there have been a number of important milestones in the development of the concept of reproductive justice and the concept of international human rights. In respect of international human rights, I could just cite a number of milestones. CEDAW was an important milestone, the adoption of a women's treaty, and the adoption of the Maputo Protocol is a product really of CEDAW. It was a desire to have a regional treaty for women. It was a contribution by African feminists who understood that women are at the receiving end of structural inequality, and that structural inequality should be addressed, among others, by adopting a treaty that is cognizant of the rights of women, including their sexual and reproductive health rights. If you look at Article 14 of the Maputo Protocol, it speaks to sexual and reproductive rights. CEDAW itself doesn't really speak about sexual and reproductive rights, but it does so indirectly. If you look at Article 12 on the right to health, if you look at Article 16 of CEDAW relating to the rights of women in relation to their reproductive capacities, you would say that CEDAW also achieves the same. But the high point of developing a conceptualization of reproductive rights as a human right was the International Conference on Population and Development in 1994. You can move on to the next slide, please. I know that this slide or this quotation is one that you are familiar with, but I think it's worth reading it in order for us to have a sense of the building blocks of reproductive justice. It also highlights that reproductive justice itself is a concept that is building on the concept of reproductive rights. The definition of reproductive health in the International Conference on Population and Development and in the International Conference of Women is really an adaptation of the constitution of the World Health Organization, where health is defined as a state of complete physical, mental, social well-being, and not merely the absence of disease or infirmity. And this was adapted to the reproductive system. Reproductive health implies that people are able to have a satisfying and safe sex life, and that they have the capability, and I would like to put emphasis on that, they have the capability to reproduce and the freedom to decide if and when and how often to do so. So if we stop there, I would like to suggest to you that reproductive justice is really a concept that is addressing the capacity or the capability to reproduce and the freedom to decide if and when and how often to do so. In other words, reproductive justice is an elaboration of the human right to reproductive health. It is highlighting that it's not enough for the state to refrain from interfering with the right to decide about reproduction. The state also has certain positive duties. It must take certain steps in order to fulfill that right, including providing access to appropriate healthcare services. But I would like to add, and I'll elaborate this a bit later on, that reproductive justice is not preoccupied with healthcare services only. It is also concerned with the social determinants of health. And that's another way of explaining the differences between the concept of reproductive rights and the concept of reproductive justice. The latter is equally concerned with determinants. Do you have social income? Are you living in poverty? Do you have adequate housing? Do you have adequate sanitation? These are important questions to ask as we apply the concept of reproductive justice. We can move forward. So we can unpack the concept of reproductive rights as a human right I don't want to spend too much time. I want to just move a little bit more so that I comment on the significance of the concept of reproductive health. One point to make is that certainly it was an attempt to come up with a holistic definition. But however holistic the definition was, I would say it did not emphasize enough on the determinants of health. And as I suggested to you earlier, we see synergy between the concept of the definition, or rather the concept of reproductive health, and the constitution of the World Health Organization. What is important there is to think about reproductive health as much more than physical or mental infirmity. This becomes important, for example, as we think about access to abortion and the grounds for abortion, that we should also be aware that psychologically, if a woman is unwilling to have to become a mother, compelling her to become a mother is a violation or an injury to her mental health. One of the interesting things we see in the concept of reproductive health is the linkage between reproductive health and sexual health. But the other aspect to highlight is that the historical development of reproductive rights was timid about mentioning abortion. If you look at ICPD, the International Conference on Population and Development, and the Beijing Conference on Women, you will see that abortion was mentioned, but for as long as it was not against the law. What reproductive justice does is to be unequivocal in that the right not to have a child is as important as the right to have a child. So it brings into the mainstream of human rights the choice to terminate a pregnancy. But as you know now, the Maputo Protocol in Article 14, paragraph 2, subparagraph C, made an important contribution by mentioning the duty of the state for the very first time in an international instrument, the duty of the state to provide abortion services that meet the grounds mentioned in Article 14. So that's an African innovation that we can move. What I want us to think about are the values that underpin reproductive justice so that we fully understand it. It's not just about the right not to have a child, or the right to have a child, or the right to parent children in safe and healthy environments, but it is also about gender equality. It's about ensuring that as between men and women, there is substantive equality. By substantive equality, we mean that we look at the structure of society. We ask ourselves whether women are in a position to enjoy their capacities in the same way as their counterparts. If there are impediments, we should address those impediments. If resources are needed in order to enjoy equality, then the state has a duty to provide those resources. Sexual autonomy goes hand in hand with recognizing the idea of reproductive justice, because where there is violation of sexual autonomy, it also means there is violation of reproductive autonomy. Equally important is to ensure that there is access to community-based resources, that is, resources that are available, are accessible, are acceptable, and of good quality. And the distinguishing mark with reproductive justice is that we are not thinking of resources only in terms of quality health care. We are also thinking about the other determinants of health. We're thinking about housing, education, a living wage, a healthy environment, a safety net for times when these resources fail. So if you look at all the cases that have come before the court where maternal mortality is being litigated, you will be struck with one common feature. The women in those cases are women living in poverty. Invariably, there are women living in poverty. So reproductive justice requires commitment by the state to respect, protect, and fulfill human rights. And as I said earlier, this should be sustained by civil society mobilization. I know this might seem a bit tedious, but it is worth highlighting the importance of the preconditions for achieving reproductive justice. And I've just listed them for you to highlight that reproductive justice requires recognizing that sexualities and reproduction are interlinked. They are affected directly or indirectly by intersectionalities, and those intersectionalities play a very important role. Your rural location becomes a major determinant. If you're living far away from a healthcare facility, you are unlikely to reach the facility in time. So we look at social, economic, cultural, gender, geographical, political, racialized, ethnicity, age, ability-based, and other power relations in order to understand how reproductive justice can be achieved. Because unless we address the different locations of women, if we treat women generically as if they are all the same, we miss the point that middle-class women have access to private health care, and their counterparts rely on the state. And they go to state facilities that are without requisite care. So it's so important to factor in intersectionality. It is so important to factor in affirming diversity of identities. Women are not the same. They have diverse identities. Some are heterosexual, some are lesbian, some are disabled. A commitment to reproductive justice requires us to affirm these identities. Equally, it requires us to recognize the different vulnerabilities and abilities. Some women may be suffering from gender-based violence, so it is important that our framework of reproductive justice is able to address that. And when we think about health, we are thinking about health in a comprehensive way. We are thinking about the mental, the physical, the emotional, and the spiritual health. We are thinking about access to community-based resources, as I said, not only in terms of quality healthcare, but also the other determinants of health. So what I want to do now is to do a little bit of a switch to take you through the development of law in terms of rendering states accountable for maternal mortality. One of the things we can do is to look at the international human rights framework. We can acknowledge that the United Nations Human Rights Council, which is a United Nations mechanism for protecting and promoting human rights, has adopted several resolutions on preventable maternal mortality and morbidity. It has also provided technical guidance to states. And this technical guidance to state highlights the importance of accountability. It imposes a duty on states to review all maternal deaths. And that's quite important, that you can only understand what steps to take if in the first place you put in place an infrastructure for conducting maternal surveillance so that you can, maternal death surveillance, so that you can respond to maternal death. The next slide builds on the case mentioned by Professor Ben Twino-Mugisha yesterday. The issue of maternal death has come before the Committee on CEDAW. This is the treaty monitoring body that is responsible for monitoring the CEDAW treaty. It's a case that came from Brazil under the optional protocol. It concerned an Afro-Brazilian woman who had died as a result of not receiving appropriate care. The committee found breaches of the human rights to health, the human right to life, and the human right to equality and non-discrimination, which at the time were also constitutionally recognized by the Constitution of Brazil. She died because she bled. She died because she was not given appropriate emergency obstetric care. She died because she was not provided with appropriately trained healthcare professionals. So what is important about this case is to note that the committee used an intersectional approach to understand the plight of the victim in this case. The committee found that the discrimination she suffered was a result of a combination of poverty, race, and gender. So in our locations, these factors can also apply. Poverty certainly applies. Race perhaps takes a form of ethnicity. gender always applies. And it is important to recognize that in providing remedies, the committee ordered personal remedies, but also systemic remedies to look at the infrastructure for providing maternal health care. And it ordered Brazil to make adequate provision for reproductive care, including providing emergency obstetric care, appropriately trained healthcare professionals in accordance with national, international standards. It also ordered Brazil to ensure that there is access to remedies for violations of reproductive health rights. And this is important for accountability. It also ordered Brazil to develop a national plan for preventing maternal mortality at state and municipal levels, including establishing death review committees. And that's quite important. A point I made earlier on, that the Human Rights Council, in its technical guidance, requires states to review all maternal deaths. We can go to the next. We have a case that comes from the Inter-American Court of Human Rights. This is the case of Chamok in 2009, where the Inter-American Court of Human Rights found that Paraguay was responsible.
We have experienced a technical glitch, but we are sorting it out and we are going to resume the presentation. Professor, can we have those 50 as we, yeah. So the technical team is helping us to return back on air. So we are trying to get back Professor Ngwena on board. We can network in the meantime as we, on your tables, as we try to get back Professor Ngwena. We are back on Zoom, but we're trying to get Professor Ngwena back in the meeting. Yeah. So Professor Ngwena is back. So we are going to resume the presentation. Professor, our apologies for that challenge, technical
No, it's
challenge.
fine. Can I continue?
Yes.
Can I continue?
Prof, you can continue.
Yeah, I'm on the regional human rights standards. I'm speaking about the Chamok case decided by the Inter-American Court of Human Rights, which held that Paraguay had violated the woman's right to life, equality, and non-discrimination. What is important about the case as in the Aline case, the Brazilian case, is that the Inter-American Court recognized the systemic nature of the violation and ordered the state to establish immediate measures to provide health care to pregnant women. Significantly, it also directed the state to conduct a study with the participation of community members and experts to identify the means for adapting maternal care to community needs. So in my view, this case underscores the importance of integrating not just a human rights-based approach, but also community participation. As part of human rights compliance, there must be involvement of the community to ensure demographic representation, especially where there is evidence of social and economic disparities that impact on reproductive health. Decisions about the design and implementation of a healthcare system should involve the affected population. This is something that Dr. Mulumba has written about, the importance of ensuring community participation in the provision of healthcare. It doesn't just apply to maternal mortality, but it applies to healthcare generally. The next slide. There is a pending case before the African Commission, a communication brought against Nigeria alleging failure to prevent maternal deaths. And in that case, the applicants are relying primarily on Article 14 of the Maputo Protocol. Their argument is that the financial, infrastructural, and institutional factors associated with the high mortality rate in Nigeria is within the control of the Nigerian state and within its available resources. So we wait for the outcome of that case. Next slide. We can look at national human rights standards, and Uganda has really been on the African continent a pioneer in this. In petition 16 in 2020, the Constitutional Court of Uganda used the constitutional rights in the Constitution to find that the state healthcare providers were liable for the death of women who died in labor. I know this case has been spoken about at length, but it's important to emphasize that it is really the first African case to address the connection between the domestic constitution and maternal mortality. But it is also the first case on the African continent to understand that national objectives can also be translated into justiciable right. The case is also important for ordering systemic remedies. Now, I'm reaching the end of my presentation, but let me go back a bit. I think I missed something. Did I miss something that I may... a sketch of what it is we can do if we wish to decolonize maternal health care and make a positive contribution. We must acknowledge that decolonization is a process that requires us to center the lives of African people. And when we talk about the lives of African people, we mean their lives in their intersectionalities. Some are men, some are women, some are old, some are young, some are straight, some are gay, some are persons with disabilities, others are persons without disabilities. So that's so important that we understand that the focus on African-centeredness is also inclusive. It is not an indirect way of restoring patriarchy. Certainly, we should acknowledge that colonization of the African continent was an event, and however, colonialism itself is much more, it has more lasting effects. We should acknowledge that our healthcare systems have been designed or redesigned by the former colonizing powers in a way that marginalizes African knowledge systems. So we sit with the persistence of colonialism and we wish to contest this colonialism. Next stage. What is it that we can do? We can look at three main things. We can look at the professional structures and the institutional biases. Two, we can look at power imbalances within the stakeholders of care. Three, we can focus on person-centered care using a decolonial lens. move on to the next stage. What is it that we can find if we look at professional structures and institutional biases? We find a male bias in the practice of obstetrics and gynecology, which we call an androcentric bias. And clearly, feminist approaches are indispensable to democratizing the practice of obstetrics and gynecology. We also should go beyond the word to look at the knowledge systems themselves, to look at the impact of the colonial legacy on higher education. So when we train doctors, when we train nurses, when we train midwives, we should realize that because of our history of colonization, Europe has been the epistemic center. It has marginalized Africa. And it is our duty to think about how we can restore the imbalances and how we can do it using evidence-based medicine. If we look at imbalances between types of staff and stakeholders of care, what do we find? We find a very long history of power imbalances between, for example, obstetrics and midwifery. So what you really want to do is to make the relationship more horizontal rather than vertical. We want to ensure that women who come to give birth are not dehumanized. Their consent is respected. We want to recenter the voices of women in the birthing process. And what do we mean by patient-centered care? We are asking the question, as was really done in the Chamok case by the Inter-American Court, is there participation by women, by the community? As I said, Dr. Mulumba has written about this. Community participation is a way of ensuring that the community is represented. We need to be aware of intersectionality in maternal care. Intersectionality allows us to be sensitive to diversity of cultures, among others, not just diversities of identities, but also diversities of cultures. It's a way of bringing humanity to the biological model that has dominated gynecology in the last 2 centuries. We think it is important that obstetrics and gynecology should value African knowledges and be able to borrow from it and take some of the positive aspects that can be found in African cultures. So I really come to the end of my presentation. Perhaps I've taken longer than I should, but that is really it. And thank you for listening.
Thank you so much, Prof, for a well-detailed presentation. It's building on the conversations we had yesterday, and I think we have now a deeper appreciation of reproductive choice. You have reassured us that we're not running away from reproductive choice of the rights framework, but rather we are building on the framework with the social justice angle. I think we have more clarity and more enlightenment of the conversations. So, Prof, we will take leave of you for now. We are descending into a panel discussion. We are trying to dissect further the issues I've highlighted, getting the lens of different participants coming from Kenya, Zimbabwe, so that we can also have that broader conversation on the emerging issues. So allow me to, again, can we have a second round of applause for Professor? Thank you, Joel. So allow me to invite Mr. Nimrod Mohomuza to moderate a panel that's going to have a conversation on how do we integrate the principles shared by Professor and those that were shared yesterday in reproductive justice and SHR programming in Africa. In case you have any questions or comments, let's note them down. We'll be able to get an opportunity to get conversation on them.
Thank you so much, Ibra. Good morning once again. So I have the distinct privilege of moderating a panel of legal practitioners or individuals that have been involved in the practical implementation of the concepts that we had yesterday, but also the concept that Professor Ngwena has just presented. So at least I think we'll be moving from some bit of theory now to practice. And my panelists are three. I'd like to start by inviting Mr. Martin Onyango. Martin is the Associate Director, Africa Legal Strategies at the Center for Reproductive Rights. I'm sure you've all heard about the organization. They have done a lot of good work in Kenya. They are Yes. He's responsible for spearheading litigation in Kenya, the Park case that we had about yesterday, the GMM petition as well. And he supports the program strategy on litigation and related advocacy, supporting the development of capacity building strategies and cultivating pro bono relationships, as well as representing the center externally on issues in the region. Welcome, Martin. My next panelist is someone that I've grown to know well, even though we only met last year, Ms. Deborah Mwase, the program manager at Katswe Sisterhood in Zimbabwe. They are partners of the Litigating Reproductive Justice Program in Zimbabwe. Deborah has been working with NGOs in Zimbabwe since 2008, and her work includes advocacy and lobbying for women's rights, and as well as environmental justice for women. So this I really like because it brings together two concepts that are usually not put together. She's been selected as one of the international fellows at the Kettering Foundation in Ohio in the United States, where she undertook research on sustained dialogue and deliberative democracy. She has also been awarded the King's College London Women, Peace and Security Fellowship. Welcome once again, Deborah. Last but definitely not least, again from Zimbabwe, is Ms. Hilda Muhumucha Tinevimbo, who is the program officer at Women and the Law in Southern Africa, also one of our implementing partners under the Litigating Reproductive Justice Program. She joined in 2021, and she's very passionate about women's rights and access to justice, particularly in rural areas. She's a feminist at heart, with over 5 years experience in gender equality and girls' rights. Hilda, we welcome. May I please have another mic? Thank you. Okay, so I'll just get right down to it. We had yesterday Dr. Mlumba mentioning the need to integrate concepts to do with social and historical determinants of health, and not just to focus on gaining a legal right to health. And as you've all litigated, you've all been litigators. So my question to you, Deborah, and I think I also like to hear from, to you, Hilda, and then I'd like to hear from Martin as well, is how do you integrate other aspects of reproductive justice beyond trying to attain the legal right to safe and legal abortion? So things like economic justice, and making sure that once women and girls have this legal right, that we can now find doctors who are available to treat them, that we can now have medicines in the health facilities that are ready to treat them. How do you go beyond the legal aspect?
Thank you very much. My approach to that would be, we are looking at mostly in the issues of SRHR, women and girls, adolescents, as the ones that are more marginalized and vulnerable in this particular scenario. And when we design laws that are known by rights holders, in other words, where laws are not known by rights holders, those laws will fail to protect the rights holder. So my approach would be to first increase awareness in the communities that we work by integrating SRHR justice in our programming. Basically, we are moving away from siloizing SRHR justice. And we're taking a broader approach, in that we're bringing in, or we are fusing, we're combining, we're blending different interventions that speak to SRHR rights in one place, or blended in one programming approach, in a bid to promote a comprehensive access to SRHR rights, as well as ensuring that there's efficiency and effectiveness. And then you'd find that moving away from siloizing SRHR justice by integrating, that in itself cannot operate independently. It would need other, just like the predecessor, the professor who was presenting. He spoke of other determinants. So for me, the determinants would be the inclusion of women and girls who are they would be potential survivors of abortion. To then say, let's include them in the planning, in the decision making, in the implementation, so that they've got ownership to the formulation or the co-creation of these rights or interventions they will be, or that will be imposed on, that will be used within their communities. If we generate programming that excludes women, and yet there would be potential people to be affected by the violation of such rights, it will be a gross violation of women's rights. So what do I recommend? To then women inclusion, community participation, so that they've got ownership to the solutions which are tailor-made to suit a particular environment, a particular species of women, whether of color, a particular women of class, in terms of the determinants that were highlighted earlier by our predecessor who was presenting. Looking at other determinants such as gender equality. So you assess the environment, the community in which you are going to implement the programming to say what sort of a community is it. As you would appreciate that within the African continent, we have got diverse culture, values, religions. All those are factors that should be considered when we tailor-make programming to suit a particular audience, community, or area. Thank you.
Thank you so much, Hilda. Martin, South Africa offers us a cautionary tale in this. Yeah, okay.
Sorry, you'd asked me, sorry. I think from also to add to what you said, from our perspective, looking at access to safe and legal abortion, I think what we have done is also look at what are some of the impediments that prevent a woman from accessing a safe abortion, even where it's legal. So you find that in some cases, it's really access to the health facilities. So it's working around those impediments, providing support in terms of getting them to the facility. And then we have issues around access to the procedures set out for getting a certificate of termination. like going to a magistrate's court. And we have noted that our magistrates' courts, they have a practice where they say only a regional magistrate can issue a termination certificate, and regional magistrates are found in provincial capitals and not necessarily at the district courts. So you find that they have to, like, Zimbabwe is huge. Like we live in corners, and then there's large areas where there's no one. So you find that they have to travel long distances to get those terminations. So that essentially prevents them from accessing a termination. So and then there are other issues where there are cases of a hospital where they can have the termination, because you'd find that in most rural areas, our health facilities are run by missionaries, by church. They're church-run hospitals, and they are not all open in terms of termination of pregnancy. So it's really getting them to a facility. And then we do have PAC, and we know post-abortion care is legal, and you don't get asked questions. But the challenges we have with PAC is really around how it has to be done in an institution where there's a theater, and it has to be done where there's a medical practitioner. So it's really also advocacy work around pushing for getting services to people, pushing for issues like task sharing when it comes to access to safe abortion, saying this is now a very simple procedure. Can't a midwife do it at a primary health care facility? Thank you.
Thank you so much, Deborah. So yes, I think Deborah touched on some of the issues that I wanted to ask Martin. That even if and when we access or we get a legal right in some of these cases, as you did in Kenya with the FIDA petition and the PAK petition, access is still restricted, actual access. So how do you advise that we go about making sure that the structural barriers are also removed?
Thank you very much. I will start from a point of clarifying that the Center for Reproductive Rights, our Africa program, we have continental work, but also we focus on 8 countries on the continent. So in the countries where we are not domiciled, because we are based in Kenya, we work through implementing partners, some who are in the room. But now to come back to your question, how do we then deal with the barriers to access to care or realization of rights, even where the legal entitlement has been pronounced in court? And I want to speak to this through the experience from a litigation experience, and how then litigation can be part of the solution to addressing the barriers to the enjoyment of the rights. Petition 266 of 2015, the JMM petition, JMM initials the minor who was defiled, could not get safe abortion, sought unsafe abortion, the health deteriorated because of lack of quality post-abortion care, ultimately died, symptomizing how then the system can fail indigent communities or individuals and deter them from realizing their rights. And when that case went to court, several things were at stake. First, the clarification of the law on access to safe and legal abortion in Kenya, access to abortion as a fundamental right, the interplay between the right to access safe abortion versus the penal prohibition of access to abortion or limitation of access to abortion in most Commonwealth countries. And so when the court then pronounced itself on the right that survivors of sexual violence have a right to access safe abortion as part of the recommended remedy to redress their violation, and that abortion is a fundamental right, and that blanket prohibition on access to safe abortion cannot stand in a country where the Constitution recognizes access to health, but also permit abortion, though in limited circumstances, similar to what you find in the Maputo Protocol. But the reality, of course, alongside that decision, the court then nullified the withdrawal of standards and guidelines on provision of access to safe abortion, allowed the continuation of training of providers and the use of Medabone for medication abortion. But the practical challenge is that then this benefits, because the condemnation was against the actions of the Ministry of Health, it simply meant that the reinstatement of the enjoyment of these rights then were quickly grabbed by the private sector. So the following day after the judgment, you see a lot of bold engagement. The private sector resuming training, out there clarifying that yes, we now we provide abortion within the law. But because the ban arose from the public sector, it meant that the public health facilities were not or had not resumed provision of care. The public sector relies on the Ministry of Health to give policy and administrative directions on what should happen. And let's bear at the back of our minds that who relies on the public sector to access health care? It is the poor, it is the indigent, it is the rural communities, it is those who are at the periphery. It meant that then the reinstatement of these rights, those who can afford to pay were then advantaged. Those who are relying on government to take up and comply with judicial decisions were then waiting for government to give that direction. And so then this gave us, and alongside the challenge that has existed historically, is the police using the criminal justice system to intimidate providers, so they shy away from providing access to safe abortion, to intimidate clients seeking care, especially adolescents. They're targeted for arrest and prosecution and extortion of providers. And this then did not change with the judicial pronouncement, that you still saw continuation of arrest, continuation of intimidation. Then it called for the next conversation. What can we do? One, to try and entrench part of the judicial decision, but also deal with the other factors that outlie the challenge that you took to court that still make it impossible for women and girls to access safe abortion when allowed by the law. And that then led to the second litigation, the PAK case. A case brought by a minor arrested from a health facility together with the provider on allegations of seeking and providing safe abortion. And this is part of the police practice of raiding health facilities, arresting providers and minors, and the main motive is actually not even to prosecute, but because the penalty in the penal law is so heavy, there is a natural inducement to bribe. So it is meant for rent seeking. But when the rent seeking does not go right, the default position applies. So the minor, together with the caregiver, are arrested. She is subjected to forced medical examination and subsequently charged together with the provider. And they're charged before the lower court. And the lower court's hand is tied to the charge sheet presented by the prosecutor. And the lower court says, raise these issues at your defense. And we tell the lower court, no, you cannot proceed with an unlawful trial even if we make the assumption that this minor sought safe abortion. The qualified provider provided safe abortion, the minor is entitled in law. The provider is qualified and has an obligation in law to provide that care. You cannot sustain these charges. But of course, the court then gets reluctant, and the enforcement of fundamental rights and freedom then sets in, leading to the case now challenging the blanket application of the penal law in infringement of the right to access safe abortion, including for survivors of sexual violence, leading the court then to now restate what the first court said, that one, access to safe abortion is a fundamental right in Kenya. And two, the conversation between a provider and the patient is protected in law and should not be violated by the police and cannot form the basis of institution of criminal charges. And that a provider offering care within the law can then not be subjected to criminal prosecution, and condemning the forced medical examination as cruel, inhuman, and degrading treatment. So why I am tying this is that then you realize that there will be, in the second case, the main respondent was not just the Attorney General, but now the Director of Public Prosecution. UN joined then the trial court, so that the conversation moves from the Declaration of Rights and duties of the state, but getting specific organs of the state then to be held responsible for respecting the legal protections. And so the PAK decisions then was an enforcement of the JMM decision, that it finally said the police cannot arrest and prosecute anyone offering services in law. And part of the reasoning of the judge was that this being a medical service, the police is not qualified to make that determination unless that allegation is being made by a qualified person, and of course the other protection. What I'm arriving at is that it then takes more than one litigation to deal with the problem, but also two, if you look at the circumstances of the minor in the first case and in the second case, it calls for then addressing much more issues than just the issue of the Declaration of Rights. What is the gender issues, the socioeconomic diversity, the availability of information, not just to health seekers, but also to providers and law enforcement. Because here you are going to court to force the police to understand that they have an obligation in law, which they must respect. And to demonstrate how that has been partly effective is that the response by the state to the PAK decision is now to cry wolf that we have been stopped from prosecuting any abortion-related allegations. We have been stopped from investigating and so on as the basis of an appeal against that decision. Thank you.
Thank you so much, Martin, for that extremely, I think, detailed description of the litigation. You mentioned, and I think I would like to ask Deborah this question. You mentioned issues to do with gender justice and as well as the other intersecting concerns. So, and Deborah, in the room we have organizations that are doing work of various kinds. We have organizations that are doing sexual minority work, minors, and what have you. And yesterday, Professor Inaugural mentioned that those that are outside the age bracket of 15 to 49, the reproductive age, are usually left out. So how do we make sure that when we talk of inclusive reproductive justice work, SRHR work, everyone that can be included is included? Sexual minorities, older persons. The cases that Martin has been talking about, were on minors. But for me, I sort of tend to feel like that usually goes under the radar, the fact that these were minors, and that alone has so many other legal and social cultural implications. So how do we make sure when we talk of reproductive justice, everyone that can be included is included?
Thank you very much. I think for me, it's taking an integrated approach because in terms of intersectionality is to look at the multiple discriminations certain people face and how then that makes them vulnerable to certain conditions. I think within the HIV sector, this has been well catered for, and we can learn something from there. Because for us, really, when we look at, we do a lot of work with sex workers. So when you then trace her story, she speaks around, no, what happened to me was I was 14, I was 15, I got pregnant, I was forced to marry, I had 2-3 children, and then the marriage didn't work out because essentially you've married your abuser. And then, so the marriage doesn't work out, you come back home, you have 3 children, you have no educational qualification, you need to support your children, you venture into sex work. As you venture into sex work, it's also criminalized. And then you are arrested at some point. You get like police now know you as a sex worker, and then someone rapes you because they feel you cannot, you have consented to, you have given express consent to sex to everyone. And then when you try to report that rape so that you can also get a termination, you are then further discriminated because of the work that you do. So I think for us is telling the story and recognizing that where I am today, they need to find out how we need to speak about the story before I stood here. So for many of these cases, for many of our interventions, we don't then just start at saying this is a sex worker seeking a termination, but we say this is a survivor of child sexual exploitation who is now a sex worker, who is now seeking a termination. We really want to trace that story. And I'm very happy with one of our judges, although it was not an SRHR case, it was a murder case, with a woman who had, there was violence and someone was killed. But when they were looking at that woman's case, because she had been charged with murder, they didn't look at her killing a man, but they looked at the genesis of the violence was when this man attacked. It was a patron in the bar, and he was sexually harassing this woman, and their retaliation then ended up in the death of this man. So it's in looking beyond what we are seeing on the surface and explaining a lot of what we see today as systemic failures that have happened. So we always say, when you see a woman on the street as a sex worker, it's coming as a systemic failure of how we failed, our social protection failed to protect children, of how our laws around child sexual exploitation are not so strong. That's why we are seeing this woman there. And when we are looking at sexual minorities, really, when they present saying, I've been violated, it's us failing to have a conversation around sexual orientation, around sexual minority, and thereby leading to stigma, and thereby leading to certain people feeling that they can, it's okay to institute corrective rape, and then us failing also to manage sexual violence against sexual minorities. So it's really a lot of systematic failures, and if we are to address the present challenge to say, this is someone who's pregnant, they need a termination, let's give them a termination, without addressing the story behind, we'll keep addressing the symptoms of already systemic challenges that we have. It's like when I say to you, I'm cold, right now when it's warm, and you give me a jersey, you have not addressed what's driving the cold. You need to get to the root cause. So it's really having conversations around the system and how it has led to where we are today.
Thank you. Hilda?
Thank you. Just to buttress on what she was emphasizing on, I think it is also important to treat each and every case within its context, and we try and embrace diversity. And with that, my approach from a programming perspective would be to create safe spaces for women, different minority groups, where we can say, in the case of the adolescent girls and the young women, we can create a safe space in the form of generational dialogues, where the adolescent girls can discuss issues that pertain to them, and then we tailor-make possible solutions, co-creating with them to come up with solutions to their access to SRHR. Whilst the young women can have issues that are peculiar to them within their context, within their economic background, their social structure, to say, let's tailor-make to suit a particular group through integrating them, making them participate, creating safe space for them. Remember, the issue of gender imbalance is cross-cutting. And obviously, when we put women and men within one dialogue, women may not be free to say more about what their perpetrator is doing. But if you create a separate environment where they can be free to openly discuss issues that affect them and their background and their context, you'll be able then to diagnose and come up with a tailor-made programming that suits a particular group. Thank you.
Thank you so much. I'm very well aware of time. I think we only have 40 minutes and we're running behind time. But I have one question now for all three of you, and feel free to answer it in the order that you wish. It comes from conversations that we've had with Dr. Mulumba at Afya na Haki, making sure that as organizations, we are financially independent and financially sustainable. And I think there was a question, there was a sense of decolonizing aid. So how do we make sure that for the sake of our own organizations and for the sake of the programs that we are running, because donors will give you money for 1 year, the program runs and it ends, but of course we know the issues remain. So how do we make sure that there is that financial sustainability, but also financial independence, which can then give us ideological and strategic independence in the way we implement our work? That's a question to all three of you.
Okay, thank you for that. Kind of complex in it. But however, my feel is it's an inference to the Afrocentric approach to say we are going to use our approaches that are unique to Africa, using our own resources, without having someone to dictate on us based on funding. So if you want to decolonize ourselves, which means from the programmatic design stage, we should come up with low-cost interventions that have got a higher impact in order for us to afford them. This could mean through community mobilization, using community structures and leadership. You don't necessarily need a lot of money to organize communities and impart knowledge on their rights to social SRHR justice on them. That would be low cost. It would mean maybe one lawyer going to the community to address and lead the community structure without necessarily having to book a flamboyant hotel and incur cost. So basically, it would need us to rethink and re-strategize on the sort of interventions we can implement or use or adopt. So to summarize it, probably it would mean we need to do more of adaptive programming, that which suits the finances available, that which suits the need of the communities, where it's necessary to just use one lawyer in the community to have a higher impact at low cost, which would win us from donor dependence. That's my thinking. Thank you.
Thank you so much, Hilda. Martin?
Thank you very much. I think the question you've asked is about resourcing our work. And I think resourcing our work and the civil society sector is a complex conversation. We start from the question of the place of accountability. Is there a point we think we will close the accountability conversation in our continent or in the globe? I think the answer is no. How do we have accountability models that then are sustainable and are not then subject to variations in availability of funding, which may come with certain restrictions? And I would address it from the first aspect is our approaches in access to sexual reproductive health and rights, and generally realization of fundamental rights and freedom ought to be anchored in laws policies, and administrative frameworks that would then be executed, applied, and adhered to and enforced locally within the national jurisdiction. So for me, that is the first approach. That what are we using the money we have now for? We need to use it in a manner that anchors our engagement in systems that will then be available or are available to hold duty bearers accountable now, tomorrow, and to provide the community with guarantees or certainty that government action is being directed in an accountable way for the realization of fundamental rights and freedom. Of course, when the funding is available, then how do we program domestically? Our programs and our intervention should then be in line with our realities. The conversation we've been having from yesterday on Afrocentric approach, reproductive justice approach, if you look at the approach to sexual reproductive health and rights on the continent, if you leave alone the approach from the north, the African continent has largely applied the approach that you would describe as a reproductive justice approach. What we are doing in this conversation, in my view, is to clarify, is to emphasize, and of course, is to isolate what more do we need to do. That we need to be more intentional in looking at our human rights framework, looking at our jurisprudence, looking at our practical implementation that has led us to advances in our African countries. Why has Ethiopia progressed in great access to care? Why is Rwanda making greater strides on access to care? How did South Africa make the progress they have made? Rather than using concepts and approaches that are not tested and improved and domesticated to our needs as a continent. Thank you.
Thank you. Deborah.
Thank you very much. Your question is very, you want me to talk about how I fire myself, how I ensure that I will not be needed. Yeah, okay. I think in terms of conversations around sustainability of our initiatives, this has been something we have had conversations about internally as an organization. And I think one of the things we have learned has been, we do work with sex workers, but we have never really received any substantial funding for sex workers. So we have seen other organizations getting funding for provision of services for key populations, and the same sex workers we work with, they've then been benefiting from those, but whenever they face certain encounters, they always call and they always know they come back home. So really, it has been work around movement building. And the importance about movement building is you have a clear ideology about what your movement is about. And I really admire like the Christian or religious movements, how they really are anchored, and it doesn't matter whether there's money, whether there's no money, people still go because there's an ideology that they follow. So in whatever we are implementing is to get our ideology clear. What is the ideology that we are working on? And I like what Martin has said around saying it has to be anchored on what is familiar to us and who we are. So it ceases to be about resourcing and funding it, but it ceases that a person is something I buy into, it's an ideology I buy into. It's like the liberation movement. It's people were driven to support, to fund, even make personal sacrifices because it's an ideology that you believe in. So it's really about getting people to buy into the ideology of reproductive justice, that it becomes self-sustaining when there is a movement of people who value it. And the other issue is around anchoring your work on what is already happening and not trying to set up something new within a community. So there are already initiatives that are happening, like as an organization, when we work with certain communities, we look at incubating already existing initiatives that are not well-resourced, but there are initiatives at the local level, just strengthening them and working on those, because they are in the community, they are rooted in the community. And even when you are to remove your funding, because this is something that they have been doing every day, then there is an opportunity for you to then continue. And then finally is issues around collaborations, especially with duty bearers, because the work that we are doing is really, there is, when someone has a complaint about the government, we all have like public protectors or an ombudsman who's supposed to be dealing with these issues. So government is structured in such a way that they are supposed to address all these issues. So it's really collaborations and ensuring that you work with these institutions so that they are able to deliver on their mandate and strengthening them. And also just building collaborations. We have been having a project we work with around GBV and HIV, the linkages. And because of the collaborations we've been having with the National AIDS Council, they have now said, okay, part of the AIDS levy that we collect from everyone, because they collect an AIDS levy through their taxes, we will give you so that you can implement projects on our behalf. So we have gotten the government to say they collect this money, and we have gotten them to an extent that they will resource our work as a collaboration between us and government. So we do get funding from the government of Zimbabwe through the money they collect from taxes to implement projects in communities. So it's really about ideology, strengthening what is there, and collaborations with the duty bearers. Thank you.
Thank you, Deborah. Hilda, briefly.
Okay. In brief, just to add on to what Deborah has been emphasizing on, I'll take you home to my own organization, Women in Law in Southern Africa, Zimbabwe. As a design stage of every project, having noted this issue of funding, we went on to say for every project, we should have a sustainability strategy that would last for over 5 years. How did we do that? As a legal organization that fights for gender justice, we went on to depend on the community and train what are known as community paralegals. The community paralegal model is worked as a sustainability strategy beyond the funding of any project in any community, in that we capacitate them on the basic thematic areas that WILSA works on. For instance, let's say SRHR. These trained paralegals would then continue to impart knowledge, but we have linked them with the government structures that are permanent, that are not affected by funding, like the community development coordinators that fall under the Ministry of Women's Affairs. These are community-based cadres trained by the Ministry of Women Affairs. Meaning to say the community itself, with the paralegals, will continue as watchdogs to report possible SRHR violations, to report GBV at community level using the community structures, the victim-friendly unity, the Ministry of Women Affairs, and you can still produce reports even without funding. That's another approach that I feel you could adopt, the paralegal model. Thank you.
Thank you so much, Hilda. A rousing round of applause for my panelists, please. Thank you so much. Ibra, you can guide on whether we'll take questions, because I know we're running a bit behind time.
Thank you so much, moderator and the panel, for the wonderful presentations. We are not doing well on time. When we resume after the tea break, we'll have some questions for Professor. And in case there are any questions for the panel, we'll do it for about 15 minutes and then we'll descend into the next presentation. Because I feel we have been seated for quite long. We have had very wonderful presentation and networking sessions, but I think we need to have a health break. Professor, we are returning in 10 minutes, then we'll be able to, if there are any questions or comments for you, be able to address them. Thank you so much. We have 10 minutes for the break. by Professor Mbazira. We'll have a moment of comments or questions to Professor Ngwena. And in case you have any question to the panelists, I think we can handle that in our discussion that we'll have before lunch. But for purposes of this session, I think if you have any questions or comments to the presentation of Professor Ngwena, I think it's the time that we raise those questions. Then we go into the presentation by Professor Mbazira and the next panel sessions. I don't know. Greg, can you confirm, Sam, that Professor is online? Anyone with a question or comment, Professor?
Thank you, moderator. I recorded here about 3 comments. They are not specifically for Professor, but for all of us, for both sessions. I was looking at a question you asked. How do you make sure there is financial sustainability? If we are going to talk as CSOs, NGOs, the answers given were so valid. But my approach would be, as a person in central government, we should recruit Parliament into our struggle. We should spread the gospel to Parliament because they appropriate the budget. The money is there, but has it been directed in this direction? If they don't know, they don't know. If they know, they know. So let's make them know. In 2013, 2014, I had 13 workshops with members of Parliament, sponsored by Plan International. And we are talking about children's rights, women's rights, and human rights. And the debate changed in Parliament. As of now in Uganda, if you want any budget passed by a ministry, there must be a gender audit. So what did Batema teach us? Gender audit. And it became a national policy. So if we are able to do a multi-sectoral approach, we strategize on how to recruit Parliament, whether we go into subcommittees, whether we have workshops, whether we are taking them out for benchmarking. We should find a way of targeting members of Parliament. Maybe not the whole Parliament, but we should identify champions of human rights. And we recruit them, we arm them with data, we arm them with these cases, with knowledge, so that when they are debating on the floor of Parliament, let's recruit the members of Parliament. There are some who are good. Here and there you'll find an economist, here and there you'll find a lawyer. And let's capitalize on those. The other question was, how do we stop the persecution and the prosecution of doctors or actors in abortion? To me, as a High Court judge, I always consider myself privileged, and I say, if I go to heaven and God asks me, what did you use your powers for? When it is unlimited. unlimited jurisdiction. I always interfere with the lower court and I say, you are handling a non-existing case. During tea time, I gave an example of police raiding a lawyer's chambers, taking documents, and then prosecuting that lawyer for hiding a land title. And I called for the file when I was in Mukona. I said, it is impossible, it's not allowed. There is immunity. You can't go searching a lawyer's chamber and charging a lawyer that he is holding on to a client's title which is required by police. I said, this is not only a bail application. I'm quashing the whole procedure. All the proceedings must be stopped and the lawyer is freed for good. So if we see these cases happening in the lower courts, I think it's our time to call for the file. Call for the file and say, I'm releasing the doctor. You policeman, never harass this doctor again, because this is a medical matter. You police constable, what medical knowledge do you have to determine whether this was a case fit for abortion or not? I think we can do that activism more so for us at the High Court. Now the CSOs and NGOs bring those cases to our attention. Some of us who are activists, we shall help. Maybe we shall talk to our friends. We shall give them the gospel. Otherwise, if you continue just fearing and hiding, these cases will end in Chibuku. They will not come to the High Court. No? They say, I have no jurisdiction. All I have to do is try this doctor. Because, for example, in Uganda, cases of abortion are handled by chief magistrates. So they never come to the High Court. We must have ears on the ground. Thank you.
Thank you, Justice Watema, for those interesting insights. I think the lawyers here who handle cases, I see people coordinating legal support network in Uganda here. Take cases to Justice Watema's court.
There was an invitation to treat from the judge. So my contribution is towards the sustainability issue. I think one thing that we're not really focusing on a lot, which we should, is to really look at the actual impact of the advocacy that we do, whether it's strategic litigation or any other kind of advocacy, beyond the court decisions, beyond even the law change, if that is what results, into does it actually impact on the community? And one project that we are doing in Malawi is legal empowerment of the community itself. So we have spent the purpose of the project is to have the community itself be empowered to actually implement interventions by themselves. So part of that is to, first of all, also realize what are the issues that affect them and engage with the decision makers themselves. So they have meetings with the police. When there is a violation, they will document that violation. They will meet with the police commissioner or whoever is in charge, just to see if there is going to be a change when the community itself starts taking these actions, as opposed to, the so-called representative action that we've always been doing. So it's still a work in progress, but my suggestion is it could be a way forward in terms of sustainability, where once the NGO goes away, like we are there for 5 years or 3 years or 2 years or whatever, and then afterwards, things just go back to status quo or back to normal. There should be sustainability and continuity, and part of that is the actual legal empowerment of the community or the grassroots community itself to be able to continue to speak up for themselves and to advocate for themselves in terms of rights.
Thank you so much. Do you have any quick questions?
I'm sorry if I'll dominate this, but with the police, it's the same story everywhere. When we sat with UN Women, we found out that UN Women is almost everywhere in Africa. West Africa, East Africa, blah, blah, blah. I was lucky to have a UN representative, Anna Mtavati, who was a classmate in Zimbabwe, in Uganda. And we drew a program to tackle the police training curriculum so that the police officers are trained. Is it 9 months or 10 months? We have 2 weeks talking about human rights, and we make sure these rights are brought out. I'll give you an example. Literally, the police know that a breast is a private part. And it took us a whole week talking to the police to say a breast is a private part, and a leader of opposition by, pulling her breasts. And we focused on that to say, when you are arresting, do you arrest the breast or you arrest by touching, by what? So the training curriculum of the police can be invaded by us. Let us go to the police training so that the police officer comes out knowing what to say about sexual and health, reproductive rights.
Thank you so much. I'll invite Professor Ngwena. Most of the participants have been making comments. Is there anything you'd like to clarify or share before we take leave of this session? Professor, over to you.
Well, I didn't really get any questions. So one observation to make, I think, has already been made by one of the delegates, which is that monitoring and evaluating the impact of strategic litigation is an important learning victory itself translated into a tangible gain, because most court victories are celebrated, but they may fail to translate into tangible gains. So that is really an important task for civil society, to always think of the afterlife of strategic litigation and develop studies that monitor what happens after a court victory, or even what happens after a court loss, so to speak. So that's my comment.
Thank you so much, Prof. And we always treasure having you in these conversations, and we will continue to engage you and we'll continue to reap from your expertise in this subject matter. We thank you so much. Can we have a final round of applause for Professor before we? Thank you so much. So we are going into our next presentation. This presentation is about advanced strategic impact stroke public interest litigation. It's by Professor Christopher Mbazira. Professor Christopher Mbazira is a professor of law at the esteemed School of Law, Makerere University, Kampala. He's a coordinator of the public interest law clinic at Makerere University and a member of the network of public interest lawyers in Uganda. He's passionate about public interest litigation and enforcement of economic, social, and cultural rights in the region. Before November 2022, he was a principal of the School of Law, and we thank him for steering the School of Law till that date. He has trained a number of litigants, a number of judicial officers in the region, in the area of economic and cultural rights. I was in his class in year 3. That's how I interfaced with socio-economic rights. He has published a lot in the area, and there are a number of books, number of judicial handbooks, number of textbooks in the area. So I think he's a very important resource in this conversation, and I think he deserves an esteemed, well-organized introduction and celebration as we usher him to the platform. I don't know how to do it, but I think we need to clap.
Thank you so much, Mr. Nsereko, for the introduction. It's always a pleasure when you see your students flourish. Mr. Nsereko is one of the students that are flourishing, and especially when you see them taking your spaces, which is also okay. Thank you so much, colleagues. Is it still morning? Good morning, good afternoon. Probably for some of our colleagues online, it could be good evening. Whatever it is, it's a pleasure to be here. It's a long time since I last appeared in context of this nature. When I took over the office of the principal, it became so hectic that I lost the time to interface with colleagues that are working on issues of public interest litigation, working on enforcement of reproductive health rights and the others. So when this opportunity came, it was something that I jumped on. And it was a surprise for me to see colleagues from other jurisdictions, but always a pleasure to be in these circles. So I was asked to prepare a paper which was intended to look at the subject of enforcement of maternal health rights in the context of Uganda, looking at the jurisprudence, the trends, and the impact of the jurisprudence. We've really come a long way, and this is something that we should celebrate. When we started speaking about economic, social, and cultural rights in 2008 through to 2010 and the years that followed, it was something that was so new. I remember at the time we started from the basics, actually, to convince people that there is actually this thing called economic, social, and cultural rights. And there was a lot of resistance from different circles, including from the judiciary. I remember interfacing with members of the judiciary here in Uganda and other parts of the continent on the subject. So it is really fulfilling to see that things have since changed, and we are now actually discussing the jurisprudence. At the time when we engaged in conversations of jurisprudence, of course, we were discussing jurisprudence from other jurisdictions, especially South Africa. So I think that is something that we need to appreciate and probably clap for all of us here that have played a big role. I see so many faces here that have been part of this. Professor Ben, Dr. Mulumba is here. I see Alan is here, Justice Vatema, and others that have really been at the forefront of pushing for the justiciability of these rights. So right now, when you look at the jurisprudence, we are just engaging with the modalities of how to enforce these rights. Of course, we have some colleagues that are coming on board that may need to go through the basics, but even then it is easy because the jurisprudence is there. Special appreciation to our colleagues in Kenya because quite a lot has been done in Kenya. When we started conversation in this area, Uganda was far ahead of jurisdictions in East Africa. Alan, isn't it? I remember the Alans used to admire us, that, at least your judges are doing ABCD. Now we are admiring the Alans. Those are the Kenyans because they have really advanced in so many respects. So what am I going to do here? The objective of the paper, and I think a draft was circulated, it is still work in progress. That's always a safe way to manage criticism. When you write a paper, you always say this is work in progress. So please feel free to comment on the paper. I was teasing Nimrod that I'm sure you've read the paper and there are so many crosses, which is okay. So the objective of the paper is to review the jurisprudence enforcing maternal health rights in Uganda for the purposes of determining its impact on improving maternal health rights. And the context is Uganda. The structure is there, simple structure. It starts by basics of what sexual and reproductive health rights are, zeroing down on reproductive rights and then maternal health rights. It looks at the state of sexual and reproductive health rights in Uganda, and then it dives into, I don't know if it dives deep, but somehow it dives into the question of litigation, looking at maternal rights litigation in Uganda, the impact of the litigation, and then a conclusion. I know most of us here are experts in this area, so I will not waste a lot of time with the basics of the definition. But one thing that we know for certain is that without reproduction, all of us cannot be here. Without reproduction, society cannot continue. So when we speak of reproduction, we are speaking of something which is so instrumental to the existence and continuity of society. And that's why reproduction then needs special protection. Unfortunately, I missed the sessions yesterday. I'm sure this was discussed or somehow discussed when the history of reproduction was, reproductive justice was discussed. But we know that historically, women have been looked at as instruments of reproduction. That's all. That's how women are perceived in so many circles. And of course, that comes with so many violations and abuses, including sexual and gender-based violence, neglect, and so many violations, sometimes that result into violation of the right to life, right to human dignity, and other related rights. And this is one of the reasons why over the years, international human rights law has taken a keen interest on this subject and crafted responses to address some of the violations that women face. We are now getting to that actually other genders as well also have reproductive violations that require to be addressed. So in the paper, I show how international human rights law has responded, akin in some respects what Professor Ngwena said earlier, trying to show the connection between reproductive health, reproductive justice, and human rights. And what is emerging is that the human rights-based approach is now being used. Sexual rights, we know what these are. Again, that is a basic. Just a minute. Sorry. Reproductive rights as well, related to the rights of persons to decide freely the number, spacing, timing of their children, and includes maternal health. Again, Professor Ngwena touched on this. Looking at maternal health, World Health Organization defining it as the health of women during pregnancy, childbirth, and the postpartum period. And there are manifestations of abuse and violations of especially maternal rights. We see this in the mortality and morbidity rates, which remain high. In our context, they are so high. SGBV as another manifestation affecting mainly adolescent girls and young women. Again, when you follow intersectionality, mainly rural, poor women that are disproportionately affected, limited access to services, and then the issue of teenage pregnancies among others. Maternal health rights are protected by human rights law, as I've mentioned, through a number of rights, including rights to life. When you look at the right to health, the right to physical and mental health in the International Covenant on Civil and Economic, Social, and Cultural Rights, it speaks of prevention of stillbirths, access to family planning, childbirth services, pre and post. Protection from SGBV is also indicated in CEDAW, in the Protocol, African Protocol, and others, and so many other rights that somehow advance maternal health rights for women. Now, when you come to the state of sexual and reproductive health rights in Uganda. Some indicators there, which we can look at. We can look at them and determine whether this is good or bad. We see that 648,000 adolescent women between the age of 15 and 19 are sexually active. We see that 60% of that category have an unmet need for contraception. And of course, you know where this is leading to: unwanted pregnancies. 249,000 women who give birth do not receive the recommended maternal and newborn care, a very big problem in our environment here. Then 1 in 4 women between the ages of 15 and 19 years give birth. That's now teenage pregnancy. The rate of teenage pregnancy is high, and that is actually something that we are not discussing as much as we should, but it's a natural disaster. It's a calamity that is unfolding, which was aggravated by COVID in Uganda, and this should have been the case in other African countries. We saw a spike of 17% after COVID, because at least when teenagers are kept in school, that environment could provide them some form of protection. But when the lockdowns came, in the case of Uganda, kids didn't go to school for over 2 years, so that protection went, and there was a spike in the rate of teenage pregnancy, something that became controversial. At some point, the ministry indicating that faith-based organizations that run schools indicating that they won't allow girls with babies or those that are pregnant in school. The ministry intervening and releasing a statement saying they should go back to school, but again, the ministry having very little control over those processes. The maternal mortality rate stands at 284 per 100,000 births. It could have improved. It has been improving over the years, and as I will indicate further, we could attribute this to the work that has been done in this area. So I want to dive into the subject of maternal rights litigation. When we speak of maternal rights litigation, it's not new in Uganda. Why? Because we've had people litigate in response to, especially to mortalities. We've had that. We've had people go to court, negligence, professional negligence, going against doctors, going against medical facilities. We've seen some of these cases go to the courts of law. We've seen some cases go to the professional bodies. These ones are never publicized, but quite a number of cases had previously been the subject of pursuit, either through judicial processes or non-judicial professional processes. But what makes the litigation that we are looking at different and of interest to us is that this litigation is applying the human rights-based approach. And when you look at the two forms of litigation, the one that is based on professional negligence, the way the cases are presented, the principles that are relied on are so different from the principles that are relied on in cases that have adopted the human rights-based approach. And the basis of these cases has been the right to life, Article 22 in our case, women's rights, Article 33, equality, Article 20 and 21, children's rights, I think that's Article 34, and Objective 14, among others. So the cases have been founded on human rights. That's what makes these cases different from the cases that have been founded on negligence. And we are grateful to SEHAD because most of these cases have been driven by SEHAD. The cases that I discuss here are cases that have been driven by SEHAD. It has not been an easy journey. It's a journey that probably, if we were in some context, it's a journey that could have generated a Hollywood movie. And one of the characters in that movie would be Nuru Nachivuka, when she was pushing the court to hear the petition and the court was reluctant, and then she spearheaded the demonstration to put pressure on the court, and she was pregnant at the time herself. standing, sitting in the front of the court and then parading pregnant women, and the court thinking the court is going to be sympathetic, but the court simply saying, "We are sorry, we cannot hear this because of political question doctrine." So you see how the Hollywood script would flow. Some of us would be in the background at supporting cast. In movies, these people that just walk around. Probably some of us would be there. But we are grateful to the work that SEHAD has done. So the cases here that I focus on are 3 cases, which could be categorized into 4, but they are basically 3 cases. Petition 16 of 2011. I characterize it as petition 16-1. That was round 1. Political question. No way. We can't hear this case. Then round 2, petition 16 to Supreme Court, reversing the position on political question and then throwing the case back. And by this time in the movie, we now see new characters coming in, like Justice Cheborion here. New characters coming on, coming into the movie, and then delivering very interesting judgments. Then the Mulago case, and then the Nakaseke case. I don't take it for granted that we all know what these cases are about. I know we've had a lot of pronouncement of petition 16, I'm sure since yesterday. Should I assume that everybody knows what petition 16 was about? Okay. Nuru, I will invite you, Mr. Ansereko, give Nuru the microphone, just in half a minute, to explain to us how 16 arose and what the issues were.
All right, thank you so much, Prof. And the team. So petition 16 is basically a case that SEHAD filed way back in 2011, following deaths of 2 mothers in Arua and Metiana, and in circumstances that we thought were actually not correct. So we questioned where the right to health is placed in Uganda's constitution, and we thought that the Constitutional Court had a mandate to play. First, because they have a role to interpret the Constitution under Article 137, but also because we thought that so many things had been done, but the judiciary had not been engaged. So the mothers basically died because of lack of maternal health, basic necessities, which ideally should be in the facilities, but were not there. So we moved to court basically to question the constitutionality of the violation of their rights, and asking ourselves why women should die while giving birth. So we thought that the Constitutional Court had mandate to determine that by women dying the way the one of Rua and Metiana died was a violation of their constitutional right to health. At the moment, or at the time, we had perused through the Constitution of Uganda, and we actually had realized that the right to health is only the national objectives and directive principles of state policy, but not under the chapter on rights. So we thought that we really needed to start a conversation around maternal health, and also remembering that at the time we were buying fighter jets as a country compared to women dying. I think Prof has provided good statistics, but at the time we had 448 die out of 100,000 live births. Also at that time, we're moving into constitutional review process. So we had an opportunity to actually review our constitution to include the right to health. So it's one of those cases that I think took about 9 years in court. Again, Prof has indicated that the Constitutional Court threw it out on grounds of issues of political question, really issues of separation of powers, to indicate that we went to court to ask for policy developments and budget indications. And we thought that it was not a very good precedent that we were setting as a country. So we needed to sit back and think about the role of the Constitutional Court. So we went up to the Supreme Court to challenge the ruling of the Constitutional Court, and the Supreme Court ordered that actually the Constitutional Court should hear the case on its merits. Hence the judgment that we have today.
Yeah, thank you so much. Yeah, so in summary, that was what that petition was about. Could I have back my PowerPoint on screen? Yeah, so that was petition 16-1, and then petition 16-2 is when the case goes back to the Constitutional Court, and the judgment is positive, so progressive on a number of respects, confirming the justiciability of economic, social, and cultural rights in effect, the right to health in particular, diving into the complex question of resources, saying you see resources is not a blanket excuse for states not to realize these rights. Conversations that had previously been so hard for the court to actually dive into. The Mulago case too, another interesting case done by SEHAD. For colleagues from outside Uganda, Mulago is our national referral hospital. My lord, that would be equivalent to what hospital in Blantyre? Queen Elizabeth. So that's our Queen Elizabeth hospital. And then in Zimbabwe, what? Okay, the Zimbabweans have disagreed. Please sort this after lunch. Another hospital. Okay. Okay, and Alan, the one in Kenya, Kenyatta National Hospital. So it's our referral hospital. Most of us here were born there, isn't it? Most of us were born there. So a very sad story. A very sad story. I don't know of apart from Nuru, who in Sehad was part of this story. Mr. Anseriko, are you part of the story? Yeah, please just give us a summary of the Mulago case.
I think the Mulago case is about...
You don't think, you know, because you are part of it.
I know that the Mulago case is about a mother who went to the National Referral Hospital to deliver. She had twins, and when she delivered, she was given only one child. There was no clear justification of the whereabouts of the second child. It took them days to move from office to office, the mortuary, back to the ward, to get information about the second baby, but no one was willing to provide information. So after some time, about 3 or 4 days, they bring to them a fresh stillbirth. That is a child who has died, but with the, I don't know the technical word, best technical word to use, but the baby was a fresh death after 5 days, but they bring them a fresh dead baby. So they were dissatisfied with that presentation of the dead baby. They went to Mulago police. Then Mulago police referred them to Wandegea police station, where the case was registered as a criminal matter. They even, through the support of police, a DNA test was carried out in the government analytical laboratory, located again in Wandegea. And then in the DNA results revealed that there was no match between the dead baby and the parents. So they were referred by Uganda Human Rights Commission to our office. We were still in Kamocha then. We
just go natural. Yeah, sure. Thank you so much. That's what actually the case was, and that's what it did. It is so interesting that when these parents were chasing after the baby or the dead body of the baby, at one point they were told, "We are sorry, the nurse who was on duty is not around. She's off duty today, come back tomorrow." Then the nurse will advise where the body is. Then when the nurse came back the next day, and she was confronted to detail where the body was, she was looking under cupboards and said, "I put the body here. I don't know who removed it. I don't know, it was here. The body was here. Who could have removed it?" But as a result of that case, things have improved. What the case also does is that for the previous cases, the cases before it, we were looking at maternal health rights in a narrow way, just the deaths, and not the rights of the child, not what happens after, how children are handled, how dead children are handled, etc., etc. But of course, the belief, something that the police was supposed to investigate, is that this baby was swapped. Is that this baby was swapped and given probably to a couple or a mother, or a pretentious mother that wanted to show that they had given birth. Could I go back to my PowerPoint? Nakaseke case, not so different from petition 16, same issues, mother dying in labor, doctor who is supposed to be on duty is pretending to be on duty formally, but the roster shows the doctor is on duty, but the doctor is in Kampala, like 50 kilometers away, engaging in private business, but pretending to be at the ward. And actually in the testimony, pretending that I was actually on duty and I was at the ward. Yet he left the ward around 9 a.m., came to Kampala, engaged in his private business, and went back to the hospital at 7 p.m. when it was too late to save the mother. So in aggregation, what these cases have done, they have achieved the following. One, we see that the cases have moved us away from those cases where we were using professional negligence with its limitations. It does not set any precedent. It is doctors judging another doctor. They don't order compensation. They don't order policy improvements. So we are now using the human rights-based approach as seen in the cases. These cases have moved us away from the political question doctrine, confirming that actually the courts have an obligation to adjudicate matters where a litigant contends that something done is unconstitutional. That is a constitutional mandate. The cases have confirmed that economic, social, and cultural rights are justiciable, including the right to health, and this includes maternal health. The cases have confirmed, and we see this coming out clearly in the judgment of Justice Cheborion, that resources are not a blanket excuse for failure to realize economic and social rights. Instead, the state has an obligation to move as expeditiously as possible. The cases have confirmed that it's the duty of the state to prevent maternal deaths. They have also confirmed that victims are entitled to relief, and also that the structural injunction is one of the remedies available to victims of violations, but also structural injunctions are available for the purposes of ensuring that there is policy review and reform. So looking at the impact then specifically, if we are to assess the impact of these cases, we have to start from the role that human rights litigation plays. There is a lot we could say about this. We don't have time. But I looked at what Siri Glopen says about human rights litigation. Interestingly, Siri is not a lawyer, but she has done a lot of work on a public interest litigation and the considerations, the dynamics. Her work, when you look at it, is mainly looking at the politics of public interest litigation. She says that the ultimate role of litigation is social transformation, which is to alter structural inequalities and power relations in society in ways that reduce the weight of morally irrelevant circumstances. And this is partly what Professor Angwena was talking about. It's about addressing factors that perpetrate marginalization, factors that put certain sections of society at the margins of society, and thereby limit their access to certain goods, economic and social goods and services. And in this case, we are looking at women, and especially poor women. Of course, as seen from what Professor Ngwena presented, if one brings in the concept of intersectionality, then we bring in other elements as well: disability, race, poverty, rural setting, etc., etc. So litigation here is being used to highlight this empowerment of women and address systematic discrimination. That's the role that litigation plays. What litigation plays, public interest litigation in general, but maternal rights litigation in particular, is to create a platform that amplifies the voices of the marginalized in social and political circles that they would otherwise not have access to. And that's what these cases have done. As much as it's not the women themselves that are standing in court and presenting the cases because there is counsel, as much as it's not the women themselves that are conceptualizing the cases, it is NGOs that and public interest lawyers that are conceptualizing and pursuing these cases. But the derivative effect is that it is the women that are standing in court and presenting these cases. That's why when I'm interfacing with the lawyers and building the capacity of lawyers to pursue public interest litigation, I put so much emphasis on ensuring that the voices of the victims are heard. The victims must be seen in court, not only physically, but the victims must be felt in the pleadings. Their story must be told in a very vivid manner, so that you see the judge knows that they are dealing not with the lawyers, but they are dealing with the victim. And this is important. Why? The Ugandan lawyers, you must have observed the trend which is taking root now, where the judges are beginning to characterize us as busybodies. They are beginning to characterize public interest lawyers as busybodies, and they are beginning to throw our cases out. It is started with a certain division in the High Court, which I won't mention, but it is creeping into other divisions. I've also had private conversations with some Constitutional Court judges, and they appear to hold the same view that there are so many busybodies that are roaming the streets. And certain judges have considered it as a personal enterprise to clamp down. Roaming the courts, eh? And from the courts they step into the streets. So certain judges now think it's their moral, judicial obligation now to clamp down on the busybodies. So that's why in our strategy we must start to ensure that the victims are heard, that the victims are visible rather throughout the litigation process, from the pleadings, from the presentation of the case, etc., etc. So what this litigation has done, in addition, it is being used to hold the state accountable for maternal deaths. We usually visualize a situation where you think that there is a problem of maternal deaths, and then you go to the ministry as an ordinary person, and then you are looking for the minister to engage the minister. It will take you years to actually have an engagement with the minister. But the moment you go to court, you actually have that engagement. And something to think about, which has worked in other jurisdictions. In our context, it's a bit difficult, but we have to find legal ways of going about it. We should begin to add the minister in their individual capacity, or the permanent secretary, whatever it is, to some of these cases. Or we should begin to ensure that actually these persons they appear before court physically, so that they are put to account. But that is something that we can discuss in another context. So women's voices are being taken care of, taken to social and political spaces where policies are made, where previously those voices were not heard. What the litigation has also done is that it has opened up civic spaces. I know so many CSOs have been formed as a result of these cases. I know so many networks have been constructed as a result of these cases. I think we are here partly because of those cases. And this comes at a time where the civic space is closing. You know how the civic space is closing in progressively. In Uganda, it is closing in much faster than it is in Kenya, but eventually in Kenya, the speed is also picking up. It's also picking up. I don't know what is happening in other countries, but it is. I don't know whether Zimbabwe has since changed. I think it was 2013 or 14, I was invited to Harare by lawyers for human rights to facilitate a training on public interest litigation. And you see, I was given instructions which I was supposed to follow. First of all, make sure you don't have any human rights literature in your luggage. At the airport, don't introduce yourself as a human rights lawyer. Be very careful. Also, know that you may be followed from the airport. Imagine, it was like they were saying, don't come here, but yet I had to. And you can imagine my fear when I boarded in Nairobi. I saw a chap seated in business class with a potbelly, putting on a coat that had ZANU PF, and I was like, now this guy is following me. Now I'm finished. Then I was interrogated at the airport like for 30, 40 minutes. And what saved me is when I told the immigration officer that I'm actually coming to see a friend of mine. And the question was, is the friend female or male? Then I said it is female. Then they got into a conversation in Shona. Then they were laughing about it. The insinuation was that I'd boarded all the way from Uganda to come and commit adultery. And on the basis of that, they let me. So I was happy that now I was being allowed to get in the country to go and commit adultery. But in my case, it was promote human rights litigation. So, Deborah, would I still go through the same interrogation if I came back? Oh, okay. You changed the wine, eh? The wine has changed, but okay. Oh, yeah. So well, this is what the litigation does. It's opening up civic spaces. So you see, as a result of promoting that form of litigation, I was able to get into a country that was at the time fully closed in terms of the civic space. And then, we were taken to a hotel. We had to drive, I think, for 3 or 4 hours. That you see, it is not safe to do this in Harare. And then we drove in the night. Probably somebody is following us. So such scary things can happen. Almost similar things have happened to me in Kenya, but those ones I will share my experiences over lunch. So one of the most recent studies that has looked at the impact of peer generally in Uganda is a study by the International International Center for Not-for-Profit Law. I was involved in that study where we looked at the impact of peer. And we, among others, looked at the maternal cases. So this is what that study finds. One, that the cases, as I've already indicated, opened up the door for economic and social rights litigation. The cases have rallied different actors to advocate for maternal health rights. We now see so many actors, including non-lawyers. At some point, actually, medical personnel were brought on board to advocate for these rights. The human rights-based approach somehow got into the health sector. For instance, one of the immediate outcomes of the cases was a training manual on human rights adopted by the Ministry of Health. What the cases have also done, they enhanced. There were processes in place of maternal audits, but the ministry was not taking this seriously. But after the cases and the pressure that was mounted, the ministry started taking this seriously, and now the ministry follows what are called the maternal prenatal surveillance and response guidelines that make provision for documentation of maternal processes from the date of prenatal services to the date of birth and the postpartum period. The cases have also somehow held the government accountable for maternal deaths. The cases have also resulted into remedies for victims. Previously, we didn't see this in constitutional litigation. We had so many cases that went to the constitutional court, where the court would find that actually there has been a violation of a right and that somebody has suffered. But in all these cases, the court would always decline to award damages. They would say that's not our function. They would push you back to the High Court for the High Court to determine whether you're entitled to damages and how much that would be. But that is something that has changed. Of course, in the Mulago and Nakaseke case, it's the High Court that awarded damages. But in Petition 16, the Constitutional Court actually awards damages in the sums of 80 million and 70 million. In the ruling, it's not so clear why the court departs from its previous position. The judge is here. The judge will explain to us. We had an interesting scenario when I was a student at the School of Law, where somebody had served as a judge and given a terrible decision. So one professor was discussing that case in class, and the student asked how a judge could make such a decision. And the professor was like, the judge is in that office. Just go and ask the judge. So the judge is here, not of course to put the judge on spot, but he could explain to us why he departed from the position that damages can only be decreed at the High Court level. And it was not raised as an issue, okay? And my Lord, you may want to know that that money has never been paid. Nuru, has it been paid now? At least as of 2 weeks ago, the money had not been paid. It has to. It has to. So, my Lord, you may want to know that family is yet to get the money. So we've seen remedies, damages, in this case for victims. What the cases have also done, away from the damages, is that we've seen changes in Mulago. As Mr. Ansereko has said, things have changed. The way newborns are handled, the way the dead are handled in that ward. And actually in 2018, just a few months after the judgment, there was that article in the newspapers. The Monitor is one of the leading newspapers here, where they were saying this is what Mulago is doing to curb baby theft. And they detailed the measures they have taken as a result of the case. In Nakaseke in 2010, we see evidence being furnished that actually modern facilities for the management of newborns in Nakaseke. Nakaseke is a hospital in a rural setting, but now there are modern facilities for handling newborns, somehow attributed to the case. The infant mortality rate has gone down. In 2011, it stood at 438. Today, and that was as of last year, probably it could have improved beyond that, but it stands at 284. I was now trying to scratch my head and determine whether this reduction is a result of the litigation. Yes, 284 per 100,000. I can give the report. I have it in the paper. Do you have a contrary figure, Prof? No. It is now standing at 280. No, isn't it? Okay. 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 Yeah. So my question here was, do we attribute this to the litigation? And I was like, somehow we do. Because in 20, I think it was 2017, I had a student investigate the state of maternal health care in Mitiana Hospital, which is one of the hospitals where the death in Petition 16 took place. And what the student found at the time is that there was actually an oversupply of goods and services used for mothers at the time, and that was attributed to the litigation. Yet at the time, the litigation was just was still pending before court. So yes, we may not have the scientific link. I could not find the scientific link to say this reduction is because of the cases. But when you look at the policy changes that have happened, when you look at the consciousness that has been created in the medical personnel, one could say there is a connection of some sort. So lastly, what's my conclusion? My conclusion is that the cases have given women, through the activists and public interest lawyers, the voice to air their maternal health rights infractions, and in the process influencing public policy that is relevant in this area. This has resulted in some policy changes which have contributed to the improvement of maternal health rights in Uganda. That's my conclusion. Thank you. I'll leave it at that.
Thank you so much, Prof, for sharing those very interesting insights, but also sharing your personal story for the Zimbabwe affair. You remind people who apply for visas and they put single. I think it is for strategic purposes. We should not feel offended if your partner's visa application has a single. It's for political reasons. He also raises a very important question of suing the minister, and then raises big questions on: do you sue the office? Do you sue the person? And then how do we maneuver around the question of locus standi? So I think as we have the panel, I think those are some of the issues that we can address. So allow me to invite Ms. Molly Nkosi. Ms. Molly Nkosi is a lawyer from Malawi. So Malawi is well represented in the meeting. She works with Afia na Haki. She'll say more particulars about herself. I don't want to miss out any of her important qualifications or achievements. I think she'll share more. And also she'll introduce her panel. So Molly, kindly come and handle the next panel discussion. Join me in welcoming Molly.
Good afternoon, everyone. As everyone has, as Mr. Sereko has said, I am a senior legal aid advocate at the Malawi Legal Aid Bureau. So we provide pro bono legal services to the marginalized and those people who cannot afford private legal representation in the country. I am currently a fellow at Afia na Haki, and basically I am here to just lead the panel discussion that discusses the different dynamics of strategic litigation in national courts. Just to lament on what the professor of law has stated, it is clear that strategic litigation is a component that helps to advance human rights, and it aims to effect greater social change and influence policies. And the cases that are used in this type of litigation establish significant legal precedents by drawing attention to injustices, increasing awareness, and changing laws and regulations and practices. At a national, regional, and worldwide level, SRHR strategic litigation can have a significant and long-lasting effect on marginalized individuals, including women, girls, and adolescents. I therefore would like to invite 4 experts in the field of strategic litigation from Malawi, Kenya, and Uganda, and who have experience in litigating in national courts in their countries, and they can elaborate on the different dynamics that, that surround strategic litigation. The first panelist is Dr. Godfrey Kangaude, who is also from Malawi. He is the executive director of the Nyali Institute in Malawi. He is a renowned legal researcher and scholar on sexual and reproductive rights. He has published relevant articles in different journals, including the African Human Rights Law Journal. And he has also played a key role in one of the most important cases that was regarding the adolescent non-exploitative consensual sex in Malawi. And this case was also presided by the Honorable Justice Mandala Mambulasa, who is also present here. So please welcome Dr. Godfrey Kangaude. Our next panelist is Alan, excuse me on the pronunciation, is Alan Maleche, who is a friend of Afya na Haki. He is a dynamic leader and executive director of Kenya Legal and Ethical Issues Network on HIV and AIDS, KELIN, and is a health and human rights lawyer. He has also been a part of one of the most monumental cases from Kenya, which was discussing issues surrounding forced sterilization of a woman living with HIV and AIDS. Thank you. Please welcome Mr. Alan. Our next panelist is Matsiko Godwin Muhwazi. He is the head of strategic litigation and professional development at the Uganda Law Society. His career commenced as a United Nations Fellow at the United Nations Dispute Tribunal, which evolved into a range of global council roles and consultancy engagements, notably including IGAD for the Sea of Aden project. He has been in the forefront of strategic litigation and advocacy efforts encompassing pivotal areas such as pension reform, electoral processes, religious freedoms, and educational reforms. He has focused on rule of law and strategic litigation and advocacy initiatives. He is a visiting lecturer at the Ugandan Christian University and has a specialized training in human rights law. Please welcome Matsiko. And our fourth panelist is a woman like myself. Denise Bibire is a lawyer and advocate in Uganda with a keen interest in human rights and sexual and reproductive health and rights. She was a top scorer and in lots of different academic awards, such as the Chief Justice Award and the Attorney General Award, amongst others. She holds a master's from Harvard Law School, where she particularly studied a course in reproductive justice. She has worked with SEHAD and the Center for Reproductive Rights in New York, and is currently the vice chairperson of the Health and Law Cluster of the Uganda Law Society. Let's put a hand for Denise, please. I welcome you, my panelists. I would really want everyone to just briefly explain, as people who have some sort of knowledge and expertise in strategic litigation, that before one is to commence strategic litigation, what are the key tools that you took into consideration that assisted and that assisted in the different cases that you have actually worked on or actually encountered in? I'll start with Dr. Godfrey.
Thank you.
Thank you so much. So I'll tell it as a story, because the way you have asked it, you may not answer it exactly that. I'll tell it as a story. And maybe I should start with, we have litigated one case in Malawi and on access to safe abortion, and we are poised for a second one. But I want to tell you how I was inspired to initiate the first one. Okay, so we were at this meeting with the traditional leaders and chiefs, and we're trying to encourage traditional leaders to support taking the termination of pregnancy bill to parliament. Okay, and then there was this one lady chief who explained the story. She said this: two parents, the mother and the father, came to her one day crying. And then when she asked them, what's the matter? You know, she was imagining maybe there's something, a death in the village. Then they said, no, we have discovered that our 11-year-old is pregnant. So, okay, now how can I help you? And they explained the story further. They say, you know what? We realized this morning that she was not feeling well, you know, so we took her to the hospital. And then when we got to the hospital, she underwent the examination. The clinician tells us, your child is pregnant. We were shocked because, of course, Adam, you can imagine how parents, you know, when a young girl is growing, what is it they first expect? They prepare for it's menstruation, the menses. That's a big thing, you know. But here they're just like told, your child is pregnant. Now, when they asked her about what was how she got pregnant, then she explained that this man was asking her when she was coming back from school to go into his house, and he did something with her. Okay, so the parents realized, oh, okay, our daughter has been sexually abused. Then, right there at the clinic, they asked, but look, this child is small, like, look at her, she's very little, and then how can she carry on the pregnancy? So the clinician answered, oh, yeah, I think this is a risky pregnancy. Then they went ahead, can you terminate it? Then he says, no. Why can't you terminate? No, I'm prohibited by the law. Then the parents were like, they tried to argue with him, and the clinician, he maintained, though, that this pregnancy is risky, but he could not terminate because of the law. Then the parents now, that's why they rushed to the chief, crying, what do we do about our daughter? Then the chief said, okay, this is what I'm going to go back to the clinician and ask him to terminate. So the chief goes back with the parents. Then she argues with the clinician that, please, can you terminate? The clinician stands his ground. The traditional leader fights until the clinician said, okay, I will terminate. Now if I go to court, then it will be you. Then the leader says, I am willing to be taken to police if you need to terminate this pregnancy. That's when the clinician terminated the pregnancy. Now that's when I didn't actually realize, that's when I realized that I was all the time imagining, you know, when we're doing advocacy, I was saying, oh, there is pregnancy is allowed to be terminated on some grounds, including saving life. But I didn't realize that kids of 11, when they get pregnant, they are denied access. So that is what inspired me that, no, we must deal with this. And then when you talk about justice, yeah, when you talk about justice, this is really something that the poor and the indigent experience. Because what do the mothers who have means do? They just fork out the money, look for the doctor, and get their daughter a termination. But it is these ones who are told we cannot terminate. So that is what led us to try to do get into the first litigation. Maybe I should stop there, but I will build up on the story. So let me give a chance to my colleagues first.
So that's really inspiring. Before I start off, I want to run a commercial break and say that today is International Women's Day, and I'd like all the men in the room to stand up and acknowledge the women in the room by clapping for them. I will lead. And on that account, I will cede the microphone to Denise to go first.
Wow, how many International Women's Days are there? Every day, yeah? Okay, to answer your question on what do you consider when you're trying to carry out strategic litigation, I think firstly is you need to understand the issue that you want to present. For any litigant going strategic litigation, your objective is just not necessarily to succeed, but to put out the topic into the public domain for public opinion, for public discussion. So you just need to be very certain about what issue. So you need to carry out research, be sure that this is something that you want to present, and also be ready to receive any feedback, yeah, from the public, since you're putting it out there for the public to dissect, yeah. So you need to know that you're actually trying to change something that is systemic. So you need to be very, very, very ready with your research. You have properly read through or even seen what has been done elsewhere, and you want it to be also done in your own country or in your nation. Yeah, so I think that is something very important. Then you also need to have an advocacy plan. So I believe for strategic litigation, it's very key for you to actually have an advocacy plan, because you need to, the advocacy feeds into the litigation. You can't just go to court without necessarily getting people to understand why you're going to court, getting the necessary support. So I'm thinking those are some of the issues you need to consider.
Thanks. So I'll start my inspiration around why what we factor in when we go to court has largely been drawn from work we've been doing with a partner organization called the Initiative for Strategic Litigation for Africa, popularly known as ISLA. And through the time we worked with them, we have come up with a concept called the SNIF test. SNIF is S-N-I-F, and the first question we normally ask ourselves is, as an organization, do we have the skills to undertake that litigation that wants to be taken forward before the courts? And then the second question we ask ourselves, yes, you have the skills, and by the skills it means people have been trained, people understand the subject matter, people are well researched on the subject matter. Then the second question we ask ourselves, is there a need for the litigation in that subject area? Because you want to avoid a scenario where you're going to court for the sake of going to court, and as Prof said earlier on, we then start getting the reputation of being busybodies, because all the time we are just filing cases for the sake of filing cases. So you really need to ask, is there a need for the litigation on that particular subject area that you're taking care of? And then you think through, and the third question is, what then is the impact you want the case to have? What do you want that case to be able to achieve? Because my understanding and appreciation of strategic litigation is that you're litigating for that to be a longer term solution to issues. The litigation should outlive the judgment. The judgment should be one that helps trigger changes at national, regional, international level. So you really have to interrogate, what impact do you want to be able to get out of this case? And it not only means that you have to win, you could also lose a case in court, but win it elsewhere, outside the domains of the legal regime that leads to the change that you want to be there. And then most importantly, the F for us is around, do you have the funding to be able to sustain that litigation? And the funding is not just court filing fees, it looks at comprehensively, indeed, the court filing fees where it's necessary, the lawyer who's taking up the case, if you're outsourcing lawyers, if you're going to engage in communication and advocacy, those also become important factors that you want to be able to take into account. So for us, we have taken the skills, need, impact, and funding is what normally informs. The other factors I'll talk about later, but that's what drives our conversation in terms of, do we have the skill? Is there a need? What impact do you want to achieve? And do we have the right resources in terms of funding to take this over?
Thank you. I'll try not to regurgitate what has been said, so I'll look at some of the two cases I've handled. I've always been either on the one side or the other, and sometimes if you have a human rights mindset, you feel some empathy for the other person when you see certain gaps. And one of the cases I'll mention in that regard relates to maternal health. At one point, I represented a medical gyne student at one of the big private hospitals here. And the challenge was that while this student was involved in the process, unfortunately, a mother lost a child. But then she took the case to the medical council, and piggybacking back from what Professor was mentioning earlier, sometimes it's important for you to understand the forum and also see what necessary support you need and who you should take on. Because when I looked at the case, I noticed that the bulk of the argument was against the systemic failure of the hospital, as opposed to the singular role of this student who comes in within specific hours and can only rely on the chart that has been given by the previous one and also recommend on that basis. And the bulk of the argument for the mother was that I insisted on him to do the examination. I forget the technical term, but the medical position is that not every doctor is supposed to physically examine for other reasons. And so the hindsight there and what Professor was saying about there are limitations to some of these negligence approaches to human rights advocacy, because then we could just say, look here, the doctor, as far as this medical school goes, what he did was right. What you should have done is to take on the hospital on the basis that the time you delayed waiting for the C-section or to go to theater was on the basis of the beds were full. There should have been a decision to say an ambulance is there, there's a driver, there's fuel, go to Mulago Hospital. That's not something a student can do. So I think that for advocates in this space particularly, we need to expand our scope in terms of when we are dealing with maternal health, and we think there's a gap, for example, from that petition 16, when we're looking at where the challenges are, sometimes it's a narrow focus when we look at individual case and the actors there. We should push for more reform, and it was good that it was reported that in Mitiana now, from professors, students' research, there was an oversupply. And I think that's something we can learn from, to say, let the wins be very specific. Let's push for systemic change, because that is where, you know, the win will be. On the other hand, in terms of how you prefer, we went to court to challenge the NSSF Act. And one of the things we were pushing for then was the midterm access, among other things. I was about to ask Professor if he benefited from that, but perhaps he's on a different position. So I feel that for strategic litigation, part of the preparation is to mark out your wins so that you don't have that fatigue in case either the case drags out or you don't win what you want. Then find collaborators. Sometimes organizations work in silos and it defeats the purpose. So for example, at Uganda Law Society in strategic litigation, we are able to litigate, but the nature of a membership organization is sometimes you're driven by pressures of what the members want. But if there's, for example, an institution that is able to do evidence gathering and bridge that gap, we are able to harmonize and make sure that if we have areas of mutual interest, we go together. So I think the conversations like this in the space are very good, because then when we find areas of synergy, then it even makes the push stronger. And I think that's part of the preparation that we can look forward to.
Yeah. So now let me add some, and I've been inspired by sniff also. I think we did the sniffing also, but only that I did. You know, because when we're thinking, okay, I'm a strategist rather than a litigator. Right? So I was thinking, we have not litigated this in my, how can we start? That's when I sniffed for partners like CRR. You have litigated in Kenya. Can you assist us in Malawi? I also went to SALC, isn't it? SALC, you know, I was bothering you in Pretoria, inviting you, can you help us litigate this issue? And then fortunately, we did get their support, but we were also learning things on the way. One of the things that I learned was we had a team of lawyers in our Coalition for the Prevention of Unsafe Abortion, and we were doing this advocacy work. Then we said, okay, we have this opportunity to litigate. I thought that when we get a case, then our team will immediately know what to do to litigate, you see? But they didn't tell me that they didn't know, because I mean, like, lawyers wouldn't like, oh, we are not sure about this. So we got our case together. I mean, we identified the case, then say, let us start, but nothing happened. Then I realized, oh no, we don't know what to do. We need to first get these lawyers to understand what we do from step A, B, C. That's when now we had the first training. We had a litigation surgery. It was supported by Sierra and SALC, where we now had a team of 12 lawyers who we started to cultivate, to understand that what do we do when we are faced with this. So there are those very same lawyers we have picked from that pool that assist us in the first litigation and also assisting us to prepare in the second litigation. Thank you.
Thank you very much. I would just like to ask you a follow-up question on that. You have really pointed out a point on what role the CSOs can provide when conducting strategic litigation. Can you just lament on that, like how best can the CSO community even incorporate other ways of supporting strategic litigation?
All right, I will start by something like negative, okay? So when I was telling our colleagues, the CSOs, that we should take this matter to court, no one wanted to support it. There was resistance. It was like, no, we cannot take this matter to court. How about if it fails? How about if something goes wrong? And we are working with Parliament. We're almost there, Godfrey. We're almost like getting Parliament to do something. Now you're bringing in litigation. How about if it botches all this? No, it made me think, now what is this that my colleagues are saying? And then I almost thought maybe we shouldn't do litigation, but I realized, it is just like, again, like ours, we did not understand what is this litigation. So we needed now to start to get a buy-in from our own, so that they understand this litigation. So part of what we do now, even as we are litigating, is to get the CSOs to support us. And it's not only because sometimes, the understanding was that court work is lawyers, and most of our CSOs in Malawi, there are no lawyers there. So I understood their fear. Godfrey, when you talk about costs, there's one CSO that was litigating something, and the Attorney General applied that the cost must be slapped on this NGO, threatening the NGO. So when the other NGOs hear that, oh, Godfrey, this is a dangerous terrain. But so now one of our tasks is really to get the CS to appreciate, and they can support in many ways. For instance, some CSOs work with the community, but we want the community to understand this litigation. When something is going on in court, we want the community to actually link with what is happening in the community with what's going on in the court. It shouldn't be like, oh, there is some court issue that lawyers are arguing about, but not connecting that is, it's something that is from their community. So we need NGOs that work with communities to actually get to raise awareness in the communities and to get the support, so that when we have a judicial outcome, the community can support it. So maybe let me stop there.
Okay, thank you. So just to add on to what you have said with regards to the need to alert and also impact knowledge on the CSO community. Denise, you've done a lot of advocacy in the CSO space. Can you just please elaborate on how best the CSOs can collaboratively advocate so that there's collaborative efforts from the CSO community on strategic litigation?
Okay, so maybe to go particular on what we are discussing today, reproductive justice. Yeah, even in this room yesterday, you could see that people didn't know what we were talking about. So I believe people are asking, oh, are we just leaving reproductive rights? Are we moving away from there? What is reproductive justice? So I believe as CSOs, we need to maybe carry out maybe values clarification and transformation sessions with the lawyers themselves, so that they can be part of the strategic litigation or choose to actually volunteer, do pro bono work, and come in to join the movement, because everyone stands a chance to benefit from this reproductive justice movement. So I believe as CSO, as CSOs in advocacy, we can maybe do VCATs, that is values clarification sessions, so that people get to understand that you can be a believer and still choose to stand for rights for the poor women who need abortion, like how Professor Ben was talking, that he's a very passionate Christian, but he can also stand and say that, you know what, there are people who need this service. Because we all know one person who actually will benefit from us advocating for family planning, for us advocating that maternal health rights and services and all the relevant resources that they need are there at the hospitals. So I believe we can just rally behind us very good lawyers that can be part of us, so that we can be a big group of litigants that are ready to take on this project. Then we can also do some review of the bills and the laws and see whether there are any lacunas, see any spaces, and these bring out the issues that we actually need to take before court. Yeah, because I want to remind you about what Sister Fatima said yesterday, that the bar and the bench have the power to reform the law. So if the lawyers don't know, how can they actually reform? So if the lawyers don't even know what is lacking in the law, how can they seek for a reformation? So I believe as CSOs, we can also take on the mandate of reviewing all the health laws that are maybe archaic, that are lacking something, and we see whether we can actually take them to the Constitutional Court to review, or even just do advocacy, seek to amend the law differently. We can also recommend, now we have, ULS has a strategic litigation department, we can also recommend some issues to them to go ahead and litigate and put out. So yeah, I believe those are some of the things that we can do. We can also do maybe like CLE trainings. For example, lawyers are very interested in getting the clinical legal education points. So if as CSOs we have money, we have the funds, we can arrange these trainings and bring them on board and train them to be part of us. That's it.
Thank you. Mr. Matiko, she has talked about you being the head of strategic litigation in the ULS, and you also mentioned that most of the strategic litigation within the Law Society is moved by the interest of the members. What strategies do you have in mind that you have in place to actually build that interest and also build momentum and also bring the recommendations from the health and human rights cluster that will also feed into building that interest into strategic litigation for reproductive justice?
Thank you. Yeah, I think in line with the theme of the conference is, yesterday we're having a part of a passionate debate around Afrocentricity. And my takeaway in that line is, and from what our colleague in Nigeria said, it's a matter of context. One of the challenges we have is most of the work we do in CSO is project-based, and some of these projects, quote unquote, are designed in Boston and sent here to be implemented. You remember the adage of the oak tree in law school. And so my approach has been, as I take on this mandate in the Uganda Law Society, is we need to be long-term players. We need to be thinking marathon. Yes, the funders and our project partners will need these sprints and these quick wins for them to register the impact that we are having. But in designing our interventions, we have to think that, one, we are dealing with things we have inherited from the colonial laws. Some colonial laws still pervade us. Then we have traditional biases, contextual, patriarchal issues, and some of those things do not take a day to change. Secondly, the context in our different countries in terms of political climate inform what laws we are having. And so if you have an election cycle every 5 or so years, if a law is passed to suit the needs of that particular regime, you might not achieve much within that. And so if you're going to be combative on every issue, you might lose the wins that you have made or the progress. And so when in the CSO community we have a mindset of a long-term gain, we are able to build on the gains that we have. We design our projects and interventions, one, to make sure we can build a critical mass of awareness. Which direction are we trying to go in maternal health? What is possible now in the next 5 years or so years? If this project ended, if the project is on a litigation case on a specific programming, how do we, in the next 3-4 years, build on what has been made to make sure it is sustainable and integrated in what can be self-funded. So it is things like that that will help us, and if we can talk to and engage our stakeholders to say, this is what you want to see, but this is where we are, this is where we are coming from, this is what we are dealing with, and in terms of progress, we can give you what you want to this extent, but we also encourage you to consider this avenue so that in 10-40 years, we can actually make the progress that you want. So I think that when we're in those boardrooms, we need to be candid with the conversations we have so that we do not pretend that everything is what it is on paper. That has forced some NGOs to manufacture statistics because they need to close the budget year. And I think that comes from a transparency gap. Are we actually honest with the people that we're working with on what we're able to do? When we say we go to court, I've had instances when I was litigating education reform, the funders are closing a funding round, and if that closes, it's $10 million on the line. But we are telling them the Minister of Education is the first lady of the country. You will not go to court and get a judge to say certain things. Yes, let's go to court, but let's also engage her. Let's meet her where she is. As a mother of a nation, as someone who loves the Bible, how does she feel like this is going to benefit her? And that conversation might take longer. So it is really having that delicate balance of what are we communicating, are we aligned on expectations, and what can we achieve? But also, let's not throw away the gains. Let's see how to build on them.
Thank you very much. Alan, when I was doing a little bit of research and on the case that Kellen was the second petitioner in, I realized that there was a lot of utilization of international legal instruments and international case law to advance the petitioner's case. Can you please give us an outlook or an explanation of what tactics that litigants can take from your experiences in litigating such type of cases so that they can advance and actually be successful in their litigation?
So thank you for that question. I'll start it off by attacking Moses because he's been talking a lot about Afrocentrism. That's proper witchcraft right there. But I want to draw and answer your question in a very broad way. And I will be drawing from Latin centrism because there's a bit to learn from Latin America, and particularly from a publication by Women's Link Worldwide that speaks to 4 factors that you have to have in place or that will make strategic litigation ideal. And it also marries with the question you're talking about. Then I'll come very quickly to why then we relied on a lot of international law. I think the first thing they talk about in their publication, and which has been true to us, is the fact that you need an existing rights framework in place. And this takes me back to when we were doing the reform of the Constitution in Kenya, and many lawyers, if I recall, kept saying, oh, you know, this constitutional reform is just about political issues, so let's leave to those who do civil and political rights. But later on, I found the benefit of involving ourselves in constitutional reform because a number of CSOs working on health rights, socioeconomic rights, were able to push that to be within the Constitution, and that has really helped us a lot in the Kenyan context to have a constitution that has got civil, political rights and socioeconomic rights, and it gives the anchorage of where you're then able to litigate. We have at least progressed from linking the right to health to the right to life to directly having it within the Constitution, and that makes litigation easier. And so I think my key message for most lawyers in the room is that if there's a law reform process in your country, engage in it, because by having a good legal framework, then it makes life easy. And so what happened to us also is that our Constitution then took the position that any law that we had domesticated was part of the Kenyan law, as if Kenya had already ratified, as if it was part of what has been adopted within Kenya. So we could apply CEDAW directly, we could apply the Maputo Protocol directly, because the Constitution then said it's now binding within the government. So that was one way. That's why a lot of international law, a lot of regional law reflects on the case for forced and coerced sterilization. I think the second thing, which is not beyond our control and also touches on constitutional reform, is around the need to have an independent judiciary. And I know sometimes it varies. I have got very senior lawyer friends. When they win cases, the court is very independent. But when they lose the case, they say, oh, this judge is no longer independent, he's serving the needs of the government. And so it's hard to be a judge, sorry for the judges in the room, to ever please anyone, because sometimes when people lose cases, they are annoyed and they're happy. But the whole issue of an independent and knowledgeable judiciary is key, because the independence helps them make fair decisions. We don't expect all the judges to always agree with us, but we want to see their reasoning as to why they are disagreeing with us and whether that is valid. But for them to be able to do that, then we also need to see what ways have they had a chance to have knowledge on the subject matter, and what way are we facilitating that, and that becomes a role for civil society to think through. But also the independence of the judiciary comes with the role the law society plays in terms of holding them accountable, in terms of being bold and honest in the way justice is being dispensed, because the more you have an independent judiciary, the more you're likely to have fairer decisions that take into account what has come forward. So again, I believe CSOs have a role in terms of pushing and ensuring that you have an independent and knowledgeable judiciary, knowledgeable in the sense that you could organize seminars like this, independence in the sense that you would be looking at how a judge is selected, how they're appointed, what disciplinary processes exist, and what exactly is the role of the law society in that. And then coming to the actual civil society organizations, just as we've seen with the experience of SEHUD and many other organizations in Zimbabwe, Malawi, you really need to have civil society organizations that can translate the problem of the woman in Mulago Hospital, not to just sit as a woman who lost a child, but to understand the nuance of how does this connect to maternal and newborn health, and how do I make a linkage of how this case will eventually have an effect on linking it to rights. As Professor Mbazira said, we are now doing human rights-based litigation. What right is being violated, and how am I drawing that particular linkage? And then lastly, and most importantly for us, is what network exists beyond the legal action, the non-legal network that exists, to be able to expand the outcome of that case, to communicate it among the judges, to communicate it among the lawyers, and most importantly, to communicate it to the affected communities and also the general public. That dissemination method is quite important. So for me, before and when we do litigation, we think through all those factors and say, how then do we move this forward? And so the reason why our forced and coerced sterilization cases had a lot of reference to international law, reference to regional decisions, was the fact that this case had not been litigated before in Kenya. And we drew a lot from the work SALC had done in Namibia, because they're the ones who took forward a case before the Namibian court around the issue of forced sterilization. We had to borrow a lot from that. And we borrowed a lot from other jurisdictions in Latin America, also in South Africa, and also in Europe around what had been done. So for us, it was a necessity because the issue had not been decided in Kenya before, and then we had to track and see how to bring other angles to it. And so the essence of having a good constitution that gave us an easier way to say that international instruments that have been ratified by Kenya are applicable and the courts can consider them made the avenue very important for us. But I just want to emphasize that the 4 points of you're making sure that you have a nice rights framework, because then that gives you the link to the rights, an independent and knowledgeable judiciary, CSOs that know how to break down the issues, the statistics, the trends, and find a way to malinate this information in a way a judge, a magistrate can be able to understand and see the causation of issues. And then also then what next? During, before, and after the litigation, how we are engaging the affected communities, how are we communicating about it, and how are we making this public, are all things we need to employ in terms of trying to be successful with the long-term impact that you're looking to do with this particular litigation. It's not just about winning the case in court. All lawyers love to win cases, but it's also about what is the case doing outside the courtroom And is it having the desired impact that you want it to be able to have?
Thank you for wrapping the conversation really well. We need to look beyond the court, just as the professor of law stated. Because we are out of time, that marks the end of our panel discussion. Of course, Dr. Godfrey is looking at me. He has some sentiments to just end the conversation, so I'll allow him.
No, actually, I've learned a lot from him. I'm going to implement what you've been saying here. But, you know, we were thinking about we have a Gender Equality Act, and that is a good thing for us. As you're saying, we have already a framework, a human rights framework we can use. So the Gender Equality Act recognizes sexual and reproductive health and rights, okay? But again, another important thing when thinking about how we can make Africanize, sexual reproductive health and rights. You know what? Part of the challenge is when we have these laws from Europe that still guide us on how we do procedure before the court. That makes it difficult for litigants to actually engage the court. But now the Gender Equality Act says that the Chief Justice can make rules of procedure under the Gender Equality Act. I think that is a good entry point. We can engage our court, the Chief Justice, to make rules that open up this area so that people should not be blocked from litigating just because it's too expensive. It actually says that the Chief Justice can make forms and determine how much to pay, you know, for those procedures. So maybe, you know, colleagues here, Kellyn, and you can help us that we use that entry point to actually Africanize the Gender Equality Act. Thank you so much.
Before you hand over to Molly, I will make an appeal so that the other panelists have a closing word, but I think now to support Moses on his Afrocentrism, the approach that we have adopted at Kellyn is to say we start with decisions made in Kenya, then we start with decisions in East Africa, and then go to the broader Africa before we quote any foreign decisions, because I've come to realize after spending a few months in school in the US, they never even consider our decisions. They don't appreciate rights. They appreciate amendments in their constitution, which don't make sense to me, because there's no right to privacy. And when I was in class saying, oh, there's a right to privacy, they look at me and wonder. So we need to start a practice of finding out what has Nigeria decided, what has Malawi decided, what has Zimbabwe decided on this issue, and how do I bring these cases forward? Because no one will publicize our cases unless we do it ourselves. So if there's one thing you don't remember from this, just remember when you're looking at precedents, bring from your neighboring country so that courts can begin quoting them, referring to them, because there are very good decisions coming from different courts in Africa, but we need to move away from only Roe versus Wade, because we now have decisions in Kenya, we have decisions in Malawi, and elsewhere. That's my plea to all of us. Let's now embrace this Afrocentrism by quoting our own, by referring to our own, and finally, to ensure Moses' books don't go to waste, we can also quote him as an author.
Yes, okay. Denise, final remarks.
Okay, by way of closing, I'm just excited about the topic of reproductive justice, because at the time when I studied it in 2017, I came back and I was wondering, how useful is this going to be? But the fact that we're now starting to talk about it is very good and hopeful, because reproductive justice seeks to observe that rights are given meaning or even lose meaning depending on the status of a person, on whether they are rich or poor, because a rich person has their privacy. You don't even know whether they are pregnant or not until the stomach starts to show, or you don't even know whether they had an abortion or not, but it's the poor lady who maybe has to seek it from a hospital that doesn't have it, or even a rich person gets the access to family planning, any choice that they want, but the poor is the one who has to actually ask for whatever is there, and that's what is given. So I'm excited because with all these cases that have been discussed by the professor, Petition 16, Nakaseke, all these cases, we now all know that there's a right to maternal health. But this RJ framework seeks to pick up from where the reproductive right stops and continues to say that, you know what, the Constitution observes that there's a right to health. But are we trying to just give it to the rich, or are we also trying to ensure that everyone enjoys it? So I'm excited and hopeful. Yeah. Thank you.
Head of Strategic Litigation, just wrap up the conversation.
Okay, thank you. For me, in closing, I would urge the members that we need to mainstream post-litigation milestone tracking. We have had so much work done by SEHAD in the last so many years and other organizations, but sometimes we do not think beyond the award. When we look at the outcomes from that, whether it's a recommendation that a law should be amended or certain reformative corrective actions, I think at barazas like this, we should have sessions to update from petition 16, where are we now in terms of how far have we gone beyond Rua? What does that mean for Rwanda in the same scenario? So it's really to see that our work plan includes the post-litigation and that we can make that part of the conversation on an ongoing basis. Thank you.
Alan has a final quote.
In living with the spirit of quoting Africans, I remember a particular quote by Justice Ogaile Dinkake, who is from Botswana. He says that a judge is only good as the lawyer and the pleadings that are presented to him. And so he said, garbage in, garbage out. So if your pleadings are not well researched and if you're not articulate, there's no way a judge can save you. So let me leave you with the message from my good friend, Justice Ogaile Ndikikake, that a judge is only good as the pleadings and the lawyers who are present before him. Over.
Thank you very much.
We thank our panel for Are you clapping for me or for the panel? I know we have another panel discussion coming up. On the program, we have a panel discussion, but since we're talking about lunch, I want to avoid the risk of garbage in, garbage out, and allow us to amend the agenda to suit the circumstances. While the agenda talks about a panel, I think there's a call for lunch, which is social justice. So with the powers entrusted in me, I hereby allow all of us to go for lunch, and we return at exactly 2:30, and we resume with the panel discussion, and then we'll have plenary conversations. I hope we are all in agreement, or there is anyone opposing the proposal. You can file an appeal after lunch. Yeah. It's time for lunch.
Welcome back from the lunch break. As we wait for other people to join us, let me take you through a quick scan of our afternoon program. We are going to have 2 panel discussions. The one on Africa's experiences in contemporary reproductive justice issues. Then we will have another panel, which will be speaking about navigating reproductive justice issues in restrictive and complex legal environments. We will then have a plenary session, and we will have another panel, which is the third, and it will be discussing legal pluralism and cases that never make it to court. And then we will have a plenary discussion also after that. And we hope to end with a presentation from Ms. Deborah Mwase from Zimbabwe, Katswe Sisterhood, who will be presenting a case that they're trying to conceptualize and file in Zimbabwe to advance reproductive justice and SRHR broadly. So that's how we are going to run through this afternoon. Without further ado, I will be moderating the beginning panel for this afternoon session. And as I said earlier, this panel is going to be speaking to the experiences that are contemporary regarding implementation of reproductive justice. So this panel has been constituted by partners that we are currently working with under the LIRA program, Litigating Reproductive Justice in Africa program. And we have had the opportunity through this program to test the application of reproductive justice, but also incorporate Afrocentrism. And so I will take the pleasure now to invite the panelists, starting with Ms. Nachivuka Noor. Ms. Nachivuka Noor is the Deputy Director Programs at SEHAD. She is a lawyer who has vast experience in research, coalition building, and coordinating. Additionally, Noor has professional training in the struggle for health offered by the International People's Health University of the People's Health Movement, as well as creative activism offered by the School for Creative Activism in Nigeria, Kenya. She has also, like Professor Mbazira indicated earlier, she has been part of a strategic litigation journey that SEHAD has undertaken over the years that has yielded very progressive jurisprudence in the field of SRHR. You're very welcome, Noor. So our next panelist is Miss Asha Mwanga. She has stepped out a bit. I hope to introduce her. Oh, she's here. I see her coming in. So Miss Asha Mwanga is a PhD Human Rights Fellow at Makerere University in Uganda. Asha is a global advisor with the Young Feminist Forum, where she works with young feminist groups. She is also a master trainer of sexual and gender-based violence in the regional training facility of the International Conference of the Great Lakes region for 12 countries in the Great Lakes region. Asha is the founding executive director of Islamic Women's Initiative for Justice, Law, and Peace, IWILAP, where she advocates for rights of women. And finally, she particularly is trained by the Coalition of Sexual and Bodily Rights in Movement Communities, in Muslim communities in Central Asia, which gives her professional and practical knowledge and experiences working on sexual and reproductive health and rights. It is no wonder that she brings a unique perspective of Muslim women to this panel. Asha, you're very welcome. Our next panelist is Mr. Bamidele Jacobs Adimola, who is from Lawyers Alert in Nigeria.
Mr. Bamidele holds a Bachelor of Laws degree from the University of Ibadan and a Master of Laws from Obafemi Olowo University, Ile-Ife, in Nigeria, among other relevant educational qualifications. He was called to the bar. He was called to the bar in 2005, so as you can note, he has very many years of experience. And finally, Mr. Jacobs Bamidele has engaged in various aspects of legal practice that have given him an edge, an opportunity of acquiring more legal experience in the areas of litigation, legal research, and he also ventures a lot in legal opinion writing. You're very welcome, Mr. Bamidele. Finally, we have Nimrod Muhumuza. Nimrod Muhumuza holds an LLM, Camlod, and is an LLD candidate at University of Western Cape, South Africa. He's a doctoral researcher with over 8 years of experience in legal advisory and 4 years in conducting academic research. So he wears the hat of a lawyer, he wears the hat of an academician, but also, finally and most importantly, he's the head of research at Afya na Haki. Nimrod, you're very welcome. So, like I said, this panel is going to be delving into the practice and the implementation of the LIRA program and how that has helped us to operationalize reproductive justice. Andrew, can I have a second mic, please? So the first question that I'll ask my panelists, and it's going to be a general question about the implementation of the LIRA program. How has reproductive justice been manifested through your implementation of the LIRA program? I would like to start with Mr. Jacobs.
Okay, thank you so much. Yes, I think it is a convenient place for me to start is to say that one, in Nigeria, awareness about reproductive justice is coming very late. And this is cannot really be understood in view of, what Nigeria is actually known for. But the truth is, in this aspect, I think we actually are lagging behind. So that being said, I would say that things took effect and really took a turn in the last 3 or 4 years. When there has started been a lot of awareness, a lot of engagements on the issue of reproductive justice. Even as a lawyer and somebody who has practiced for about 19 years, I will honestly say that even though I didn't start in the development sector, I started as a private legal practitioner, for about 14 years before I veered into the development world. I must say that I never come to know about reproductive justice until about 2 years ago. But the last 2 years or 3, there have been a lot of activities in the area of spreading the gospel in relation to reproductive justice. Why this has come so late? If you ask me, I cannot really tell you. I don't know why. But then it will also be good to admit that even in the whole of Africa, this did not really start very early. Because reading through, what we all know about reproductive justice, what we have been able to learn in this meeting in the last 2 days, we come to realize that as far back as 1994, there have been movements, in this regard in some other countries. I can imagine a whole lot of, about 30 years, before we, or a little bit less than that, before we start talking about that. But I will tell you that as it is right now, this program has really brought a lot of impetus and a lot of motivation to the movement and the campaign, just as I've said before, and I've alluded to the issues of reproductive justice in Nigeria. And as to what we are doing as an organization that's talking about Lawyers Alert specifically, I would say that this project, which we are doing in collaboration with Ahaki, Afia, Nahaki, honestly, a lot of activities and life has been brought into this. We started one by carrying out a stakeholder mapping. That was what we started with when we started this project sometime late last year. We did a stakeholder mapping where we went through and tried to discover the whole lot of organizations that work in the area of SRHR generally, and to discover their strengths, what resources, challenges, what can they bring on table, and all the rest things. And we followed that by a meeting, and a very comprehensive meeting where organizations and individuals were invited from different parts of Nigeria. And as we know, Nigeria is a very large country. This is a country where you have about 36 states, apart from the Federal Capital Territory. This is a state where you have a population of close to 200 million. We can begin to imagine. So people were brought, individuals, organizations were brought. We had meetings where this awareness actually started. And I must confess that since this time, honestly, the message or the gospel, so to say, has been spread everywhere and is being taken everywhere. I think that's a little that I want to say at this stage in order to give others the opportunity. Thank you.
Thank you, Jacobs. I will have a follow-up question for you later, but for now, let's hear from Ms. Nachivuka Nur. Ms. Nachivuka, some of the proponents of reproductive justice have argued that the vindication of rights is not sufficient, and therefore there has to be a paradigm that goes beyond the rights framework, and that is the RJ framework. So how has reproductive justice, or how has SEHAD used the reproductive justice framework to program their work and execute their interventions?
Thank you so much, Lenny. Allow me to say that the conversation we're having is not a new conversation, and I think it's a conversation that has been on for years. And specifically, we are looking at an issue of choice and dignity. And to this one person who owns a body and should be in position to decide what they do with their body. So in our so many years of engaging in this area, because it's not new to us, it's an issue that we've been working on. And I feel like it's, Lyra is just helping us to contextualize what we've been speaking about. Right from that journey of litigating Petition 16 to conversations of what are you doing with cases of women that die of unsafe abortions, and to cases that we have before court today on the same. So in that journey, indeed, it's been clear that you cannot file a case and leave it at that, because it comes back with issues of who understands the context within which you're speaking about. And I think for us, our experience has been, first of all, to identify the stakeholders that are involved, because you cannot speak about reproductive justice and look at the woman without, broadening to who surrounds this person that has a body to decide on. So in our engagements, we've actually realized that beyond the paradigm of reproductive justice, you need to think about stakeholder involvements. And I'll just give an example. Of late, we are handling a case from a BIM, where the woman decided to make a choice to terminate her pregnancy. And within communities, once not empowered, they will proceed to do what they wish to do. So she made a choice, which we all agreed to, and initiated the termination. Definitely, once initiated, you run to the facility to seek what we call post-abortion care service. She has made her choice, And the health worker is one person who was sworn to actually save a life. They swear an oath to say we are saving lives and goes ahead to say, let me do my best to protect this particular woman's life. But at the time she was coming in, she was anemic. And being government health facilities, we know the challenges that really come into play. So she comes in when she needs a scan, but there's no power in the facility for 2 days. And the health worker has nothing to do as a stakeholder, but to tell the woman kindly, go to maybe a private facility, but do a scan. Being a person who made a choice, she also opted not to do the scan. After all, the health worker has done his best, and therefore the woman feels like she's better. Days later, she again starts the bleeding and the pain and goes to now a private facility, not the government facility. When they do the scan, they actually realize that she was too anemic, she's rotten, and she needs to have the uterus out. So the question posed here is, where is the stakeholder that is involved, and how do you protect this stakeholder? Because while speaking about reproductive justice and what we've seen, I cannot blame the health worker because they are working under conditions that should be provided for them to be able to save the the life. So we are having all these cases. And one thing that we are identifying is that beyond the litigation, we need to think about a paradigm of, engaging stakeholders so that they know. Now, when you come to me as Sehad, I'll come on the side of the health worker to actually protect her in court, or him who actually provides the service, to say, look, they are doing what they're supposed to do. Post-abortion care is not criminalized in this country. We know what the law actually does provide. But should we say health workers should not provide services as stakeholders in the paradigm of, ensuring that there's reproductive justice? So we've opted to sensitize health service providers because we realize that there's a huge gap between law and health. And yet, these two should be working in collaboration with each other, because you, as a health service provider, you come across the law, or as a lawyer, you actually need information from a health service provider. So we've opted to go into sensitizations and entered into MOU with various stakeholders. The other issue is to bring the conversations that we are having to the court of public opinion. When we litigate petition 10, I think it's one of those silent cases that are not known. Petition 16 is known, but petition 10 is not known to everybody, because the strategies we took on petition 16 were to do an outblown public matter. But petition 10 is one of the kind. But we're working in a situation where we have taken the state to be a religious state. I have not read in the Constitution where we're saying that Uganda is this particular, or taking on this particular religion. I have read to say, is in the Constitution, that we are a secular country. Therefore, whether I'm a Muslim or not, I take on that. So one of the reasons why we took on a public interest matter but opted to remain it silent, because it's challenging Uganda's failure to create a law regulating termination of pregnancy. Yet under Article 22, it is more or less mandated. When you read the Hansards, the country is mandated. So while we want to engage the public, we actually realize how sensitive some matters are and why we need to kind of let the public know. So many more engagements of the public, one after another, and discussions for them to understand why bringing the issues becomes quite important. Of late, we, as a country, have a lot of money that goes into post-abortion care. Yet we should have saved more if we put in this money to sensitize the public and health workers, and less in post-abortion care. But we put in a lot. I think one of the speakers here from Ogu yesterday said they do not document abortion as a cause of death. They document hemorrhage and all that. And the medicine on the market, we actually indicate another use. Maybe you're controlling bleeding, rather than put the problem on point. Why? Because culturally and religiously, we've made this issue a problem, yet we should be speaking about reproductive justice. So other areas have come into community sensitizations, because the issues we're speaking about are issues that affect the community. So if I don't come to a team of border riders to explain to them where at a particular point a woman will have to make a choice, it becomes a problem. When it comes to rallying behind, they'll be the one behind the beating. Yet if you made a choice, it should be a respected choice. But the question is where you're heading to. Are you able to receive the service that you need? So we've done other areas of advocacy, including engaging the ministry. I indicated to Prof. Mbazira, when he presented here, that he did not indicate to us that actually the government has taken steps on some of the cases in petition 16. But why is the government picking interest to implement the court judgment? It's because they realize that the court is telling them, give us a maternal death audit report for a particular year. And they're saying, wait, what is the problem? I have the report with me, and I'm sure some of us have it here. But the report is quoting the court judgment to say, look, court is telling us that women are dying. Please act. And the ministry is acting by doing a country surveillance of what actually leads to the death of women. And they're coming up to say we actually don't have supplies, it's an issue of attitude and all that. So we realize that sometimes advocacy and lobbying are approaches that we can take beyond litigation. If we had sat on that judgment and not went to the ministry to explain to them why it's important for them to act, perhaps we would not be seeing these things. So I feel like these are beyond, the paradigm of litigation and advancing reproductive justice. What are those other things that we need to think about? Thank you.
Thank you very much, Noor. I think you give us very, very vivid lessons from your experiences. And the things that stand out from what you said are that we need a multi-dimensional kind of approach, but also we need to speak to the context and engage the stakeholders that are involved. That leads me to my next question, which is addressed to Ms. Asha Mwanga. Asha Mwanga, you are working with a unique community, which is the Muslim women, who are often neglected in programming for sexual reproductive health and rights. How has reproductive justice contributed to alleviating some of those challenges that you face in your programming?
Thank you so much, Lenny. Just like you have stated that I'm working with a unique community, and indeed it is a unique community because I'm working with the Muslim community, first of all, for starters, but more specifically, the Muslim women. If you followed yesterday's presentation, I think if I may refer to Professor Ben's presentation, somewhere he alluded to the fact that Islam, for example, actually provides for reproductive justice. Indeed, it is. But then the question we should all be asking, if stakeholders like Professor Ben, who are not even Muslims, actually know some of these facts, to what extent is this then known within the Muslim community? If I posed this to all of us here, both the non-Muslims and the non-Muslims, regardless of whether you're scholars or not, you would definitely get largely a negative feedback. It is largely known that within the Muslim community, that Islam, for example, doesn't provide for reproductive justice, and OSRH that we are trying to move away from, which is definitely a stereotype, I would say, but also lack of information. I want to bring it to our attention. And why there's a reason as to I'm giving you this background. To bring it to our attention, just like Professor Ben said yesterday, that Islam largely provides for reproductive justice. But the challenge is those who preach it do not preach it the way it is stated. And for me, as a person, I've already said that if Islam was to be preached the way it is, then definitely wouldn't even be having the challenges that we are discussing here, for example, reproductive justice. The Quran itself, that is the holiest book of Muslims, has over 30 chapters, for example, and over 30 verses that all provide for reproductive justice. We have a full chapter within the Quran that talks about just a Muslim woman and her rights, including the reproductive health and or reproductive justice for this case. We have another chapter called Surah Mudathir, and it talks about bodily autonomy and reproductive choices. But you see, even Noor here, who is a Muslim woman here, she will tell you that she has never been in a mosque where they talk about, maybe in a Jummah prayer where they are discussing or preaching reproductive health. Now, with the coming of LIRA program, first of all, I want to think that we are the only faith legal-based organization, I think, in the LIRA program that is doing this. But not only among the leader partners. In the entire country, Uganda, there is no other organization that is doing any other organization that is faith legal that is doing reproductive justice or sexual and reproductive health advocacy. We are the only organization, the Islamic Women's Initiative for Justice, Law and Peace. So obviously with that, it puts us at the center of, being stereotyped, being name tagged, and of course now as the executive director trying an organization, being name tagged as somebody who is bringing in Western values and cultures that are anti-religion. So how we have manifested all this into our programming, we are very intentional, first of all, and deliberate on who we work with. We've selected out key stakeholders like the Uganda Muslim Supreme Council. We are working with the Qadi judges, Sharia court judges. The challenge, like I've already mentioned, is that whereas, like I have stated that yes, Islam is very positive about reproductive justice. Even those who claim to be the scholars of Islam actually either do not know that reproductive justice is provided for, or if they know, they intentionally refuse to speak about it. So we are very deliberate on who we work with. We have definitely have had to follow or rather face challenges. There are many times when we have brought Sharia court judges and we tell them to speak about things like abortion, and then this judge comes and says, you know what, imagine you've collected everybody, like here, you're going to conduct a sensitization, and then a full district card comes into your meeting and is telling your participants that actually the Quran does not provide for reproductive health, specifically on issues like abortion. Maybe let me comment something on abortion. And first of all, we had an activity which we call Muslim Women Health Series, in which we bring card judges to talk to women about reproductive health. And then there comes this judge, and he puts it to our participants how abortion is not provided for anywhere in the Quran. Of course, we had to complain. And then the next Juma prayer was all about the organization and how we are bringing Western values into the community. But the Quran, if you may compare it with Uganda's penal code, they are largely in tandem on the issue of abortion, to the extent that just like the penal code gives exceptions through which a woman may have an abortion, that's how the Quran is also stated. And just like Professor Ben yesterday was saying that we may not have to maybe advocate for everything. How I wish we only at least concentrate for what is already provided for. For me, if I were to follow the Quran, I wouldn't be so much interested in preaching that, we want a full Quran that is talking about abortion, because we already have exceptions that we are not benefiting from. We have so many women who are not benefiting from abortion, even in cases where their health is at stake, even in cases where the baby's health is at stake. So we are very intentional on who we work with. Even our activities that we are implementing, they are very selective on what we want to achieve, which in this case is reproductive justice. Maybe for now, I'll stop there. Thanks.
Thanks. You highlight a very key issue of stereotyping. Reproductive justice, the essence of it is to capture the socio-economic and cultural context in which we exist. And there are stereotypes that religion on its own actually limits people from realizing their rights. But from your conversation, you say that the Muslim religion actually provides, to some extent, SRHR, and I think that speaks to our context. We can be able to interrogate that issue further and see whether that's enough or we need to go beyond that. But let's stop there for now and call in Professor Nimrod. Dr. Nimrod, sorry. So Nimrod, what is the place of research in this reproductive justice argument, and how is it going to help us advance sexual reproductive health and rights on the African continent?
Thank you so much, Lenny. So the place of research. The simple answer to that would be that research is indispensable to the discussion. I think yesterday you had Judge Okalandi saying, bring the cases to us. So I think the same thing with Justice Cheborion, Barishaki also saying, the courts are ready, the courts are willing. We need to craft arguments in such a manner that we can get, these broad societal changing decisions, and that's at the center of what we do at Afya na Haki. Research is critical to all the programs and the projects that we implement, not least, of course, LIRA. One of the things that I like bringing to the fore, because for us this has also been a sort of evolving journey at Haki. When it comes to especially issues, for instance, on reproductive justice, issues that are as contentious as this, when it comes to issues, for instance, of determining when does life start, I don't know how many civil society organizations are doing research on an Afrocentric understanding of when do African cultures consider that life begins. And the reason why, for instance, that was, I had a question like that was reading the Kenyan constitution that declares life starts at conception. And I always wondered, okay, says who? And it's the same thing that informs our Afrocentric approach. We want to do research that informs our programs, that informs our strategies bottom up as opposed to top down. And again, the whole discussion on Eurocentrism and Afrocentrism, we're not going to find out what is Afrocentric. We're not going to find out what is Afrocentric if we do not conduct research, if we do not investigate what our cultures say, what our societies want, and what the communities that we serve are actually asking us to do. And I was very happy with the discussion that, with the presentation that Dr. Mulumba gave, with the presentation that Professor Tunomukisha gave, because every strategy, every litigation, every case has to be backed up by facts, has to be backed up by evidence. Yeah.
Thank you very much, Nimrod. Just to follow up, you have been spearheading the team that's developing a reproductive justice framework. How do you think that this framework is going to revolutionize work in SRHR?
Okay, that's a big one on revolutionizing. But a number of organizations at the international level, the likes of Mary Stopes International, Planned Parenthood, and so many organizations that are in this sphere are doing a lot of self-reflection in terms of how they carry, because they have very, very, I would say, problematic legacies in terms of how they carry this work going forward. And it's the same thing with the Haki. Haki doesn't necessarily have the problematic legacy that those organizations have, but as part of our sort of self-reflection in terms of whose ideology are we pushing, whose agenda are we executing, how do we remain the voices of the grassroots communities that we are speaking to and we're speaking for, and that's the whole point of the framework is to guide our work going forward. To say, okay, we believe in Afrocentrism, we believe in the philosophy of Ubuntu, we believe in decolonization and decoloniality. What does that mean for SRHR work? And we mostly want it to be grounded on a very, very solid foundation. And so if I was to give Dr. Mulumba gave a snapshot of the framework, but it speaks to all those things, that there has to be intersectionality, that you cannot do SRHR work in silos, because like so many participants have mentioned here, you will win the legal right, but a woman will still not have access to safe abortion because of conscientious objections from health workers or because medicines are not there. So intersectionality has to be there. Issues of legal pluralism. In Uganda, much as this is a litigation baraza, I was reading a report by HIIL that indicated that only 5% of the entire population uses the court system for purposes of accessing family justice. So why the 95%? Who is serving them? which legal systems are they using? How do we reach them, and how do we make sure that because of the inaccessibility of the court system, we use other systems that that they are used to get them reproductive justice. So the framework is trying to touch on all those things to guide our work, again, from a bottom-up approach, using a bottom-up approach, but majorly to be guided by Africa, for Africa, by Africa, with Africa. Yes.
Thank you very much for that enlightenment. Mr. Bamidele, I'd like to ask you one more question. The environment, the SRHR landscape in Nigeria is highly polarized, and there's a lot of criminalization of SRHR. So how are you using the reproductive justice framework to tackle some of those challenges, like the criminalizations, and how are you navigating them? Do you have strategies that you're using?
Okay, thank you very much. I think I will want to agree with you that Nigeria is one of the African countries that have most restrictive laws when it comes to the issues of reproductive laws on reproductive rights and reproductive justice. So the question is, it's a challenging one, I must tell you, and not only that, it is also a very complex one. A very complex one because when we have a legal system where you have on a particular issue, for example, you can have up to 36 different laws on the same issue. And when I say that, I mean, for example, the federal government, the National Assembly passes a law, then the various houses of assembly of the 36 states have different laws on the same issue. I mean, especially when those issues fall under what we call the concurrent list of our constitution. So, I mean, that underscores how complex this system can be. But then, it is not all hope lost. When we started this campaign, what we did was there was a training we had towards I think towards the end of June, and a large meeting, a 4-day meeting specifically for lawyers. And the aim of that was to really strategize on how we are to go about this. Because formally, this the LIRN program, I mean, is just taking place in 2 of the states, Abuja and the Commercial Nerve Center of Nigeria, which is Lagos State. So, but then, when we were to get lawyers together, we actually advertised for it because we wanted the best, those who are really interested and are ready to work. So we advertised nationally. And different people, different lawyers, cutting across different aspects of practice, cutting across different interests, people from government, private practice, people from CSOs, and other private individuals actually put up application, and eventually we screened those applications and were able to select mainly from Abuja and Lagos, but then we try to also expand it to other states so we can also have unintended outcomes for, what we intend to achieve. We come together and actually got the lawyers trained. It was during that training that we designed a strategy where we want to do all that we can to really be able to reach and maximize the resources, and both human and material that was at our disposal. I do remember that specifically there were people we invited from the academia. I remember specifically one person who came from a state university, Benue State University, who was the head of the law clinic of that university. And I also will not forget one particular director in the Ministry of Justice in one of the southwestern states, particularly Oyo State, who attended the meeting. So at that meeting, we strategized and actually went into what we call the division of labor. We assigned roles and say, okay, this and so person coming from so and so, work on so and so. Then so and so persons, those from the academia, it's going to be on research. Those from, from private legal practice from your state, these are the issues you are going to or really face more. So we assigned roles and actually gave timelines as to what we intend to achieve or within or stated or periods. But then I must confess that one very challenging thing that we have had in Nigeria is the issue of people really coming out to ask for legal services when it comes to the core or reproductive issue or that such as safe abortion. You at least probably because of the discrimination and the stigmatization that are associated with this, you hardly see all people come out to want to litigate. And even when they come to complain, the traditional thing that we have in Africa, you see somebody comes up today and say, and cry and cry and cry, but in a matter of a week or two, he or she comes again to say, look, it appears the families have intervened and the way it is now, I think I'm not going to press more with this issue of or approaching the call and filing or a case in this. But then, for those ones too, we are not relying mainly on or litigating these rights in courts alone. We are also employing the alternative dispute resolution mechanism to actually wade into these things and see how we settle, even while carrying or the idea of law into it, rather than leaving things to the whim and caprices of or the dictates of tradition and or traditional practices. So I think that is basically the approach that I want to talk about as it is right now. Thank you.
From your conversation, I pick that you are involving stakeholders such as the academia, and you're trying to work collaboratively with other stakeholders, which is helping you to sort of navigate some of the systemic issues or the criminalizations that are happening. But also you underscore a point where you say that you use informal systems to sort of divert from what would be a rigid judicial system or legal system. And I think those are key points that you make. I will move on to Asha. I said I would ask you a follow-up question, and you mentioned, Jacobs, do you have something to say?
Yes. Okay, maybe. Okay. Yes, there is another important aspect that I think must be mentioned, which is the integration of the media into the whole of this campaign. I remember in the first stakeholder meeting that we had, honestly, members from the media actually constituted the chunk of the invitees to that meeting. And we did that simply because we believe that awareness was key. Before now, that awareness has never been really there. But that is not to say too that I cannot sit here to claim that we have created all the awareness. It is still far from that. But then, whether we like it or not, it has started, and the message is getting out there, and with time, we believe it's going to get very far. Thank you.
Thank you very much. So Asha, you said that you have interventions that engage the Kadi courts, which are also provided for in the Constitution of Uganda. How do you then balance the limitations that the law gives and the liberties that are provided for in the Quran, and how do you access that system?
Thank you, Lenny. I'm glad you mentioned that they are provided for within the Constitution, so which is the starting point. The unfortunate part is that, yes, whereas they are provided for within the Constitution, specifically under Article 129, they are non-functional because there is no enabling law. So even the Kadi courts or the Sharia courts that I'm talking about have actually not been set up by government. The Uganda Supreme Council, being the overseeing body, went ahead and put up informal structures in their own system that we are calling Kadi courts. And of course, there are cases that have been decided on their jurisdiction, quite a number, around 4 cases in regard to their jurisdiction, and still there's still a contestation on whether they are actually legal or not legal. Here, cases that go to the Sharia courts. But getting back to your question on how we try to balance, I think for me there is nothing much to balance, but rather our emphasis is on whether they actually have capacity to hear cases that relate to reproductive justice. Because even in their informality, the fact is women still go there with cases of reproductive justice or reproductive health. We have seen women who have gone in these courts with abortion-related cases. The challenge that has been there and that is still there, of course, with the coming of the LIRA program, we are making some strides in building their capacity, but many of them, like I alluded to earlier, they actually didn't even know that Islam actually has a rich provisions on reproductive justice. We have tried to build their capacity. We have seen drone lessons, and obviously, like I alluded to earlier here, that some of the would-be key stakeholders, in this case, people like the chief card, the district chief card, that anyone would think that they are actually well conversant with reproductive justice, do not actually know that this is provided for. So in whatever we do, being lawyers, for starters, we have not done anything that is illegal. We preach what is provided for within the Constitution. And not only in the LIRA program, we've had campaigns on the implementation of Article 129. In 2021, we did advocacy up to the UN CEDAW committee, and if you look at the 2021 concluding observations of the CEDAW committee, you realize that even UN, the CEDAW committee went ahead and actually recommended that CADI courts should actually be established. On the issue of when they will be established, I also don't know, but we are working, and we are working within the informal structures that have been established by the Uganda Supreme Council. Some other person's views may be different on the legality of these CADI courts, but the fact is they're provided for within the Constitution, but then the government has not done anything. The Constitution only empowers the Parliament of Uganda to come up with an enabling law, which has never been the case since 1995 to date.
Thank you. I think you bring very pertinent issues to the fore. So the final question that I have for my panelists is that we have different organizations represented here, and we all have initiatives that we are advancing all towards one end of realization of SRHR. But how do we harmonize these initiatives, and how do we sustain the wins that we've gained using a framework that we have been preaching all through this Baraza, the reproductive justice framework?
Thank you, Lenny. First, I think it's having such engagements because you get to know who is doing what and how we come together. And I think this comes in handy because oftentimes partners are taken on via working in silos. And you can only hold together what you have worked on if you actually share it. So for such engagements like such a Baraza, it's one way of saying this is how far we have gone, getting other partners, even out of Uganda, to understand what we're doing and learning from each other. That way you're consolidating gains. I'm sure the team that has come out of Uganda are actually listening into what they are doing. We are also listening into what they're doing, and we are able to have these gains together. The second is really documenting. I feel like there's several lessons in here, but if you ask me where these lessons would struggle to pick them up, I'll just give you an example. We I think have been working on cases of reproductive justice since 2011, and we asked Prof to kind of help us document these cases. So he says, okay, I want someone who has the history. And I realized I had the history, but it's not documented anywhere. Other people have moved on. So I think this gave us an analysis of why it's important to document. And you document the story as raw as it is, because then someone will know that, okay, in South Africa there was this problem. We solved this problem like this. The challenge was like this. And if I really wanted to take on the same approach, I'm able to pick on that documentation from someone else. I think my last point would be on looking out for the people that actually do the work. I love the fact that we have several professors in here. I invite to become one of those, and doctors, and also senior officials in here. So picking lessons from those that have been there before us is quite important. I'm sure even if we may not have something written, but you're getting closer to a judge to understand some of the issues they see is quite important. So I think that is one of the things we need to think about. And last, that I usually think we don't pay attention to, in having conversations on reproductive justice, several people are affected. In one of the engagements, we were speaking to the magistrates, and they said, you people, you don't know what it means, and the resident state attorneys, you don't know what it means for you to sit in a case. And the person was giving an example of a robbery case that somebody came and robbed, and you're going to go to your house and you have no security or protection, and you're thinking, okay, this is how this person walked in, this is what they did, and you spend the whole night awake. Now, when it comes to reproductive justice, it's even challenging for people who listen into these cases on a daily. While you're hearing how this girl was tortured, you're hearing how this woman was struggling, you're hearing cases of how this one was abused, and where's someone's psychosocial support? So I think these are things that are not documented, but the lessons that we need to take forward if we have to take forward the gains. What is LIRA doing, for example, partners? Just today I've been discussing with Betty and telling Betty. She shared a case of a health service provider who they opted REN to give, legal services because he's been accused of procuring an abortion. And in the instance where the lawyers are there shouting, oh yes, we can support GOT bond, a person has no license. Now, the trauma this person has gone through to listen to the case and all this, and you come to the person who has no license. So I just told her, you know what, your lawyers give a legal opinion that you're not able to provide them a service, because what are they doing? They're quacks. But the trauma is not documented anywhere. So how will someone who wants to take on reproductive justice tomorrow know that actually before you get in here, these are the things that you need to prepare for? So I think we need to think about that, but also taking forward the lessons that we have beyond East Africa to other continents, beyond Africa to other continents, to know that in Africa we're having these conversations, right? And therefore we are moving this far. We are doing this in Nigeria, we are doing this in Uganda, we are doing this in Zimbabwe and all other countries. And what do they learn from us? And what do we have to learn from them? Thank you.
Thank you very much, Noor. Asha?
Thank you so much. I think for me, I will highlight three key issues that I think should be brought to our attention. Coming from my background as a Muslim female lawyer and human rights activist, from my discussion, you realize that I highlight the plural legal system that we have in Uganda, to the extent that, we have to follow the mainstream laws, and then we have the Muslim personal law. We don't have, I wouldn't want to say that we have like a Muslim personal law system yet, but the fact that Muslim laws have been provided for right from the Constitution and Article 129 in regard to the Sharia courts. We even have the Mohammedan Act, never mind, it was enacted in 1906. That is a discussion for another day. And then, so like how do we draw the balance between having the mainstream legal framework versus the Muslim personal laws? Because usually there is a number of contradictions. And if I may just refer, for example, to the majority marriage age, whereas the Constitution of Uganda is looking at 18 years as somebody who is ready for marriage, the Marriage and Divorce of Mohammedan Act is very silent about who should marry. But again, the same act since 1906 has been advocating for registration of marriages of minors. But at least until this year, it has been outlawed. I think a few months ago, like 2 months ago, 2 months ago. So then how do we draw the balance? But again, also refer to, since I am coming from a faith background or from a religious background, the Quran, again, that we believe so much in as Muslims, whereas it doesn't pronounce itself on the majority age of marriage, it at least pronounces itself on who is ready for marriage. How do we determine somebody who is ready for marriage? For example, look at things like their intellect, how do they comprehend marriage? But like I have said, that those who know this do not actually preach. The ushers who would be preaching this do not have space within the religious framework to go out there in the mosques and, bring it to the attention of those who would want to listen. But Noor has clearly stated here that we would want to learn from, best lessons and practices from the other partners. And I want to largely agree. The other time in Rwanda, I was chatting with one of the leader partners from Nigeria, and we were sharing that actually they have rich Sharia courts, a very, very active Sharia courts. In Uganda, we do not have the same. So having partners, leader partners from Nigeria who have Sharia courts, definitely that is something key that we would want to take advantage of. And lastly, of course, research, like Nimrod here stated. I want to think by end of this discussion, or even prior to the start of this discussion, quite a number of us here didn't know the extent to which Islam provides for reproductive justice. A number of us here didn't know that actually we have over 30 chapters and all 93 verses that are only speaking about reproductive health. We have over sexual health and sexual relationships are pronounced 31 times within the Quran. But we definitely cannot arrive at this if we are not doing research. So research is very, very key. Thank you.
Thank you very much. Asha, Jacobs, please.
Okay, if I get your question correctly, the question is how do we leverage on LIRA to actually take forward issue of reproductive justice? Am I correct?
What I asked is that so many players in the SRHR environment are doing undertaking initiatives to advance SRHR. But it seemingly is that they're doing them in isolation of the others. How do we then take forward the gains and wins of every individual participant and sustain that?
Okay, thank you very much. I think what is key here for me is the issue of partnership. Partnership in the sense that one organization cannot be everywhere. And as a person, I'm a firm believer in the more the merrier. And I say that because, in fact, even if you don't even have that orientation, you are forced to do that in a country like mine, Nigeria, where, you are distant apart, where you have, just as I said before, different laws on the same issue. In fact, if you are going, even though, if the moment you are qualified as a lawyer, your qualification entitles you to practice throughout the federation of Nigeria. But then the question is, sometimes too, there are little differences here and there as to the procedure and every other related things. And so if you must or have much impact, then you just have to partner with other organizations and partner with other individuals, especially or people close to where you may want to have your activities and have more impact. And so, just as I've said, for me, what is key is a partnership, and that is what we are doing through this project. Just as I said earlier, we have been able to call together lawyers from the court across different parts of Nigeria, not just the project or states, FCT and Lagos. There are lawyers that, in fact, some of the cases we have harvested already are not even coming from these two areas. I remember two vividly. One is coming from a state called Kano, and the other one is already coming from a state called Oyo. So these ordinarily are states that are outside the project area. But because we have been able to work, we have partners in those states, there are people on standby, there are people on ground there to actually take over these cases and attend to them when they do arise. And so, if you ask me all the way, I tell you, partnership, partnering, because that will give us a lot of synergistic effects. Thank you.
Thank you. And finally, Nimrod Mohammadan.
Okay, thank you, Lenny. Mine is to echo what Noor and Asha have said. The theme of the Baraza is reimagining a regional approach. And I think we need to start thinking at that level as well, for a number of reasons. First, of course, we know there's safety in numbers, right? So if we work as a regional, if we strengthen those regional networks, it will help offload the burden on on one organization doing everything. The other, I think, is if we say SRHR and reproductive justice are for everyone, let them be for everyone. Let them be as inclusive as possible. I liked the point that Professor Tunomgisha mentioned, the elderly. I think that's a group that has been completely neglected. And yet that is an inevitability for all of us. So we don't want to get to a point where the moment you fall out of the reproductive age range, there's no organization advocating for you. There's no one that you can speak to about any SRHR issues that you have. Then the other point I liked was what Alan mentioned when they're talking about when they're litigating, they think first Kenya, then sub-regionally, then regionally, then that's when, before they go internationally. And I think we need to work towards, when it comes to litigation, we need to work towards developing an African jurisprudence that is insulated from the politics of foreign courts. If they repeal Roe v. Wade, fine, it may have implications for us here, but we should not worry about the decisions that have used Roe v. Wade as a precedent in African courts. Yet we have very good decisions from Kenya, from South Africa, from Uganda that Noor and Asha have been involved in. So I would just like to re-echo that we need to think, again, like Jacobs has said, synergistically and regionally as a collective going forward.
Thank you very much. I think my panel has done justice to the topic. Please applaud them again as they go on to take on their seats. I now yield the floor to Mr. Sereko Ibrahim to take us through the next person.
The 50 bucks.
If a 65 man can be here, why not you? Please. I told you yesterday, every part of the body, including the other parts, he works. No, don't worry. So let's start. Are we start now? Yes. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50.
Thank you so much, Professor, for that important exercise. I wish we have an extra 50. So, So we thank the previous panel for those wonderful insights. We are going into our next panel, and I'll be honored to moderate it. The panel will be discussing how we can navigate reproductive justice issues in a restrictive and complex legal environment. We have a number of distinguished panelists that are made stars. I'll start with the first one, Dr. Adrian Juko. Dr. Adrian Juko is the Executive Director of the Human Rights Awareness and Promotion Forum. Kindly join me in welcoming him. I was still... So Dr. Juko is the Executive Director of the Human Rights Awareness and Promotion Forum, HIRAP. He's a celebrated litigant. We crossed our path in court in a number of occasions. He handles litigations in what we consider complex legal issues. And he has authored a number of books. He's teaching law in a number of universities. He has trained some of us here in the room and the rest that are attending virtually. So he's best placed to be part of that panel that is going to dissect the complex issues or the deep issues. We've been talking about deep issues since morning. The next panelist is Deborah Mwase. She has become a famous discussant throughout the Baraza. Is this the third or second panel? She's saying it is the second. I see she even has a third panel. So it means that you have a wealth of knowledge on the subject of conversation. So Deborah Mwase is a lawyer in Zimbabwe. She usually calls it Zim. I don't know what Zim means. She works with Katswe Sisterhood. It's a feminist organization in Zimbabwe. They undertake advocacy, they undertake litigations and empowerment on health and SRHR issues. Deborah, I think it is time that you take your seat. I thought you will sit this side, but it's okay, you can stay there. The next panelist is Mr. Sevavi Kenneth. The table is already celebrating him before he appears here. Mr. Sevavi is a partner, founding partner, Springs Advocates. He's also a founder and executive director of Springs Public Interest Hub that advocates for access to justice for the vulnerable. We hope to hear from you how you handle complex issues of vulnerable groups in reproductive justice. He has worked with a number of partners in this room to litigate SRHR cases. He's part of the legal team that is waiting for the judgment in Petition 10. So he has done a lot of litigations in the past 10 years, and he will be sharing with us a number of insights. So we have a very rich panel. Lastly, and this was on purpose, is, pardon me if I don't pronounce the name well, but we are in Africa. Every name is correct, the way I pronounce it. We have Majonjo Tambuzai Mubaiwa. She's a deputy director at the Southern Africa Litigation Center. She's a lawyer. She has litigated cases. She has coordinated cases. She has supported cases in the region. So she has a wealth of knowledge, and she will traverse Africa in the course of her conversation. So if you allow me, kind of allow me to join them and we start our conversation. The judges grant me permission. Who am I to stop? So I'll not go in the order of the way people are sitting, but I'll start with Dr. Juko. Dr. Juko, we are talking about complex and restrictive legal environments. Most of the countries that are represented here, if I do a quick scan in the legal frameworks, especially on the subject we are discussing, reproductive justice, most of the legal frameworks are either restrictive on reproductive justice issues, some are unclear, you don't know the correct position, you are at crossroads, am I right or am I wrong? Then others are totally outlaw reproductive justice issues, especially abortion. And also, one of the other cross-cutting issues is that reproductive justice issues are more skewed to public health. But the legal frameworks that regulate public health are criminal in nature. You find that most of the provisions are in penal laws, which also raises a number of concerns. So, given that you have litigated on issues that some people might not either say or present in pleadings or even put on their laptops as they type pleadings, but you have stood out and litigated those issues. Can you share with us briefly your experience?
Well, thank you very much. The issues doesn't want to talk about LGBT issues primarily. Those are the issues that are quite difficult, and that's true. In the different causes that we work, including the one in Uganda, LGBT is seen as a no-go area. So, okay, he wants me to speak close to the microphone. Okay, just this afternoon, I was on Twitter, and a professor of law was disputing a statement issued by the Ministry of Health, questioning why they had to mention sexual orientation as one of the grounds against which people shouldn't be discriminated in access to health services. If you guys have been following the story, yesterday the Ministry of Health issued a statement stating that no health worker should essentially deny services to any person, including on the basis of sexual orientation, in light of the Anti-Homosexuality Act. My response on Twitter was, hey, this boat sailed, because you are talking about access to services and non-discrimination, and you have a law in place that requires health workers to report people who come to them seeking services are based on sexual orientation grounds. So a professor of law is asking, why are you listing sexual orientation as a ground, yet it's not in our constitution? And for me, that simple question also means a lot. If you say sexual orientation is not in our constitution, what does that mean? Does that mean that LGBT people are not human beings that are worthy of protection from discrimination? Those are questions that we have to ask ourselves. We are right now litigating against the Anti-Homosexuality Act. For those who are not Ugandan, or for those who have not been following, we now have an Anti-Homosexuality Act in place. On 31st of July, it marked 2 months in force. The act criminalizes homosexuality. So now there's an offense called homosexuality, no longer sexual orientation, an offense called homosexuality. So if I find you having homosexuality, that's a criminal offense. You can also aggravate it. If it's aggravated, then you have the death penalty. You face the death penalty for aggravated homosexuality. So we are operating in an environment that is actually criminalized. But beyond criminalization, there's also stigma. People look at the area that you work in. Sometimes our fellow lawyers are like, hey, which kind of lawyer are you working on this kind of issues? Like, hey, where did you go to school? How can you do this? Even police officers stand up and tell you, hey, man, you're a lawyer. Which kind of lawyer does this kind of work? So these are complex issues to navigate because people have lots of sentiments about them, because people have feelings about these issues, because people don't also understand and appreciate the challenges that LGBT people go through. This afternoon, I just issued a report on the violations that we've been recording since the act came into force from 31st of May, 2 months. And I've been asking people, you've been saying that the Homosexuality Act is not being enforced. What do you mean by enforcement? When a law passes, the law, even if you don't arrest people under the law is already being enforced. We are seeing many cases of evictions at this moment, right now, of LGBT people. Landlords throwing out people because they are gay. If you declare this meeting as a meeting of LGBT people, you wouldn't have gotten this space, perhaps, because essentially hotels are also criminalized from hosting spaces, from hosting conversations about LGBTI people. So we have about 26 cases in the past 1 month of evictions by landlords documented in this country. We have 21 cases of violence, actual beatings of LGBTI people, especially transgender people, over their sexual orientation. We have 6 cases of arrests of LGBTI people over their sexual orientation. 3 of those right now are under charges of homosexuality itself. And they are in the courts of law in Uganda, and they're also in the police stations. Many people see this as something that is invisible, but it's something that happens every single day. Now, to address your question more clearly, there we come in as lawyers. So we've gone to court and we've done more than 12 cases in the past 10 years of LGBT rights. Some of them have been successful, some of them have not succeeded, but we've scored some major victories, more especially around discrimination. The fact that every single person, regardless of who you are, is equal and important. And for me, one of the things I want to point out is that using the law is critical. You know, the law is for every one of us. The law provides for equality for all persons, not just some persons. The law provides that we all cannot be discriminated, including on the grounds of sex. And the International Covenant on Civil and Political Rights has actually extended sex to also include sexual orientation and gender identity. So the work is not easy. There's harassment. People are in hiding at the moment, and I'm not even sure right now if what I'm doing right now is not promotion of homosexuality. Let me hope there are no police officers. Judges, you can't arrest me, you have to wait. But police officers, you know, because what I may be doing right now may be regarded as promotion of homosexuality. Because you talk about it, you normalize homosexuality. And that, what does that mean for the person on the street? What does that mean for you as a lawyer? What does that mean for all of us as we seek justice? So that's the background of the work that I do and the challenges, some of the challenges that I may say that we face as we do this.
Very passionate. Professor, I'll come back to you. I have a number of questions here or comments. Deborah, can you share briefly what your experiences you have in Zimbabwe? Because I believe Zimbabwe and Uganda, the laws are seemingly the same in terms of abortion and reproductive justice. What has been your experience?
Okay, thank you very much. I think I'll speak to my experience around criminal prosecutions of women who would have terminated pregnancies. So just to give a background, a lot of the when a woman chooses to terminate a pregnancy, she doesn't care what the law says. It's not an impediment. She will find a way to terminate. So in most of the cases, when women are terminating, they prefer to terminate a bit later because that's when you can actually note whether there's been a complete abortion or it's incomplete. Because in the earlier stages of pregnancy, it's difficult for them to tell whether there's been a complete abortion. So that's one of the reasons. Then the other reason is normally when a woman falls pregnant and the partner might be saying we are in this together, and then they don't show up. So it's normally in the second trimester when you're actually seeing that this person is not going to step up. And then, or when you see that economically I will not be able to do this alone. And then the third aspect is on younger women who have not been pregnant before, that they are not aware of the symptoms because of our limited comprehensive sexuality education. They might not be aware that this is actually pregnancy. So by the time they can tell that this is a pregnancy, they are well off maybe towards the end of the first trimester. And when they start to explore options or try to have a conversation with the partner, by the time they then get access, is already late in their termination, in the pregnancy. So we do encounter late terminations. So what then happens when it comes to a late termination is a lot of the women are arrested whilst they are trying to dispose of the fetus. So we have had cases of now the woman is trying to dispose the fetus once they've done the termination, and then they are caught either by neighbors or by employers, because we have a couple of domestic workers who have been arrested. Either they're caught by their employers or by whoever. So then that's when most of them are arrested. So when it comes to arrest, normally they are charged with either concealment of birth, infanticide, but at times, normally they charge them with infanticide if there are reports that we had a baby cry in that room, but we have not seen the child. If there are reports from neighbors or, so they may be charged with infanticide. And then the third, normally when sometimes they deliver and it's a child and they decide to put it somewhere or to just abandon the child, then it becomes exposing an infant. So there are different crimes that they are charged with. So the challenge now comes when they are arrested. Normally the arrests are driven by emotion. It's a lot of community members. Like there's a group of people going to the police station to report this woman. There are pictures circulating on social media. So the first thing is, instead of prioritizing that the woman should first get medical care, that then doesn't happen because of mob pressure from the mob to say arrest her, look at what she has done. And then once they are arrested, hardly do they have a lawyer present to take their wound and caution statement. So normally they confess to whatever charge is read out to them. So they confess. And then by the time you reach them, they have not had medical attention and they've already, their wound and caution has already been taken. The police can detain them for up to 48 hours. So the 48 hours has lapsed and they are now in court. And when they get to court, when I think the good thing is we have judicial officers here, they know the procedure of after a person pleads guilty, that you really have to make sure that the person knows what the elements of the crime that they are pleading guilty to. And we feel that at times this is not even done because concealment of birth has issues to do with gestational age of the fetus. That's hardly determined. So they are normally convicted on their own guilty plea.
Deborah, can you paint for us a picture of how easy it is or difficult it is to approach courts or to litigate reproductive justice issues in Zimbabwe, briefly?
Well, in terms of criminal defense or the civil part, if it's strategic litigation,
any part you want to handle.
Okay, so when it's the civil side, there are certain issues that are difficult. I think there's a worrying trend. It was raised in the morning. That's that judges are saying NGOs are forum shopping, or they are busybodies around courts. So what has been happening of late, and that we are quite worried about, has been issues around costs. That your case will be dismissed on costs, and it has the potential to bankrupt you as an institution when costs are awarded against you. So there's that aspect around costs. And then there's also the aspect which there's been conversations around the jurisprudence you get out of court, that at times judicial officers avoid the case and they dismiss your case on a technicality that they could have cured, that can be cured. So they don't then engage with the merits of the case. And I think it was also pointed out earlier on that this SR, they'll just, maybe they may grant it, but they have not engaged with some of the human rights aspects you have brought out. In that way, it means you only get justice for your present client and cannot effect general law reform through that litigation. So there's those issues around the kind of jurisprudence you're getting, and also the worry around issues of costs. And finally, in criminal offenses, when a person states that I need a lawyer, do you want a lawyer? And they say yes, they stop proceedings, thereby even stopping proceedings for bail. So that's another issue where you are penalized for asking for representation. Thank you.
Thank you, Deborah. Tamzai, sorry to jump, Mr. Sivavi. I'm coming back to you. But Tamzai has her organization has done litigations in Zimbabwe and Malawi. Do you mean that based on issues that Deborah has shared, the fear of costs, the fear of asking for representation, the consequences that will come. Should we just withhold, retreat, and abandon litigations in those two countries? What do you think we should do?
Well, a retreat is not an option. Yeah, Malawi is a very huge culprit in this, and I'm glad that we have a judge from Malawi. I think just last week or a couple of weeks ago, colleagues were actually mulched with costs for postponement of a case because the judge was not happy that they had not submitted some document which he demanded on the day that they came to court, which had not even been made an issue by the other side. And now they are facing a situation where they'll have to think about raising 3,000 USD or some other amount to pay the state. And so the effect of that obviously is it's chilling on public interest litigation. It also raises the cost highly. In terms of what to do, well, we do what we've always done. What we can do is to litigate. We'll continue to litigate until the courts recognize the fact that they should not be shutting out people from getting justice, and that is shutting out people from getting justice. I think one of the issues that's also happening in Zimbabwe is I heard someone saying that the Chief Justice could make rules that make procedures simpler. Unfortunately, perhaps we have not engaged with the Chief Justices as much as we should, because I know that in Zimbabwe, there are recent rules that came out that actually increase the costs of filing cases in the civil courts, where the court costs are proportional to what you are claiming. So if you are claiming 10,000 US dollars, you have to pay, I don't know what percentage it is, but it's as if you already have the money, you know? And that, for commercial cases, perhaps you could say it's justified, I don't know. But when it comes to public interest litigation, it defeats the purpose. And so I know that, I think it's Zimbabwe Lawyers for Human Rights and the Zimbabwe NGO Forum have filed cases, again litigating, what can we do? Have filed cases before the courts raising this as constitutional issues to say when you have high court costs, you are shutting us out. So those are issues that are very, very pertinent.
What strategies have you adopted? Because we are facing a restrictive environment that is complex, that is painted with fear. What strategies have you adopted to see that litigations are flourishing in Zimbabwe and Malawi?
Okay, well, it's not just Zimbabwe and Malawi, but anyway.
Anywhere in the region.
Of course, you know, we have a strategy right now that we're employing. We have judicial officers in our space. And fortunately, their ears are open, I'm sure. So one of the strategies that's non-litigious is engagement. Sometimes, obviously, the litigation space is very confrontational, and at times the responses that you get there are in line with, you know, the space that you are at. But when we are where we are here, we are able to actually engage and raise some of these issues and have a back and forth. So that's one strategy. Another is to use our law societies. That's what they are there for. Assumably, they are the representatives of the lawyers, and they're supposed to be able to take the issues that are arising to the judiciary, to the bench, to the justice ministries, the attorney generals, all of the officials, to say these are the issues that are arising when it comes to access to justice. Can we address them? I know that in Zimbabwe, I'm not sure about Malawi, they have these judicial bar bench colloquiums, right, where you have lawyers and judges addressing mutual issues, because obviously the judiciary also has issues with some of the things that we do as lawyers. So it's engagement as well.
Thank you. Mr. Sebavi, I know there are a number of creative practice areas, commercial, civil, to mention but a few. Why do you choose to go for complex, restrictive legal environments in terms of your litigations?
Well, the panel is equally laughing. But I'll attempt to respond to your question. Thank you, Mr. Ansareko. To me, I think the starting point, like you rightly said, there are other areas of law, practice areas of law like commercial land. I want to say public interest litigation is passion-driven. You must have the passion for it. You must love it. You must see how to deliver through the thick and thin. And because of the passion, you are prompted to think further and also to strategize on how to break even. Truth be told, that there are a couple of restrictive legal issues, and many of them stem from the actors and the key players in this, where you have the police, you have the court system, you have the hospitals, you have the lawyers as well. And our role is to see how we break even amidst these challenges. For example, I'm in our public interest litigation, we have prioritized key aspects, and among which are, one, the passion aside, the preparation. My former employer, James Nangola, used to tell me that a case of whatever nature, whether public interest or commercial, is won at the table and is equally lost at the table. When you are conceptualizing the case, that is the point where you win the case, or that is the point where you lose the case. So we have paid attention and detail to that. We have held strategic discussions in conceptualization of these cases. I have, through my journey, assisted SEHAD to litigate a number of strategic cases. And one key aspect that is never lost is the conceptualization of these cases. We sit through meetings and brainstorm, get a devil's advocate to look at the other side of the coin, and ensure that at the end of the day, you have what you call watertight pleadings, such that even when the other side looks at them, they have little or no room for escape. I remember one most challenging strategic discussion was the case of Mulumba Moses and another versus the Attorney General and the Minister of Health. That was the case involving we're taking on government for failure to regulate the prices for treatment of the COVID-19 patients. And we had a discussion which included the board members of SEHAD, and Professor Ben was roaring. I remember that time it was on Zoom. And it was a case that we had little evidence because we did not have the human face to the case. We did not have any affidavit. You see, Professor in the morning was talking about involving the litigants into the case, bringing them to court, for court to see them, for court to hear them. And here we're relying on reports from the media and also social media reports that the prices were indeed high for treatment of patients. But we sailed through and managed to convince the board that we have a good case. Yes, we lacked some bit of evidence, but I want to assure you that when we took it to court, I remember asking the representative from the Attorney General's chambers that, is this the case you want to challenge? And they said no. It is actually a wake-up call for us to regulate this industry. So preparation is key to that effect. Then, of course, the other aspect that also comes out clearly, being strategic. We have heard that working in silos is dangerous, and we have shunned away from that kind of practice. When we filed Constitution Version number 10, we're lucky and happy that HIRAF also filed constitutional petition number 25, the Human Rights Awareness and Promotion Forum, headed by Mr. Adrian Joko. They filed that petition. Petition 10 of 2017 seeks to challenge the omission of government to enact the law that regulates the termination of pregnancy. So when Attorney General responded, said, no, there's actually law. We have the penal code sections, we have section 141, 142, and 143 that regulate the termination. So what are you talking about? So we're happy to learn that HIRAF became proactive, strategically filed the constitutional petition number 25, seeking to declare those sections of the penal code that had been alluded to by the Attorney General unconstitutional. So we are really looking at court now, and we want to believe that we have attacked from this side and left no room for Attorney General to escape. So the strategy and the coalition in areas of mutual interest, we want to believe will deliver good results for us. So that way, it helps us to convince some of them, those restrictive covenants.
Thank you, Mr. Sebavi, for that attack from the side and the side. I think it's a very interesting approach. I don't know how we can legally term it, but just note it's an attack from the side and the side and the side. Then Attorney General is in the middle there. Dr. Juko, I know that despite the complexity of the environment, you have approached court in Uganda and East Africa. What are those strategies that you have adopted to not to just sit back and mourn, but you have approached courts? What are those strategies? What are those motivating issues that we can replicate in the rest of the countries?
Thank you. You see, the fight for equality requires the use of all the different organs of the government, of the state. So if you look at the principle of separation of powers, you have the executive, the legislature, and the judiciary. On one hand, Parliament doesn't like LGBTI people. At least Uganda's Parliament has proved twice in the past 10 years that it doesn't like LGBTI people. So it has passed 2 laws. Anti-Homosexuality Act 2014, nullified by court. Anti-Homosexuality Act 2023, court is still sitting on it. So we don't know what court will say eventually. But the fact that the president gets his say by having to sign the law means that the executive gets their say. So legislature passes the law, executive signs it. So where do you go? You know, the answer has already been given, the judiciary. And the thing about the judiciary is you can't chase us away, dear judges. That's the problem, that's the thing. Courts will hear you regardless of who you are. Unlike Parliament. We went to Parliament and the Speaker told us, you
can
can't
you
come.
clap for that?
That's not by design. That's not for the courts, the judges. It's for, basically that's the design of the constitutional system. So courts cannot say we cannot hear you. They can delay your case. They can play around with it. They can refuse to say things, but they have to hear you. And if you have your principles correct and right, they will have to give you a judgment, and the judgment in your favor. If you look at the history of our cases, the first case that we brought to court was in 2007. That preceded me. I hadn't come out of law school then. The case of Victor Mukasa versus Attorney General, which the late Justice Sarah Chamako decided at the High Court level. So police officers go into a house, pull out someone, and they say, well, we are arresting you because you are gay, but we are doing this for your own protection. Okay? People want to kill you, so we are going to arrest you for preventive protective custody, something like that. And then they take you to the police station. They start touching you. They undress you to see if you're male or female. They deny you the use of toilet facilities. They call you whatever names they want to call you. Then they say, no, it was for your own good. This was the argument of the Attorney General in court. Justice Sarach said, this is not about homosexuality. It's about human rights. You cannot do that to a person, regardless of who they are. So, very good arguments, centered in the Constitution, and we've been building on those cases. The next case was done concerning Rolling Stone, a newspaper. We woke up in the morning and the newspaper had a story that had faces and names of people suspected to be LGBT with a byline, hang them. You know? So they gave names, addresses, and faces of people, and the byline was we hang them. We took them to court. And Justice Musoke Chibuka gave us an injunction restraining them from publishing again. And then continued to court on different issues. We went for the registration of SMAG, Sexual Minorities Uganda, And the court said, this time around you're not getting away with it. We are not going to register this organization, which is a very unpopular decision in my view, because right now, even in countries like, even I think Swaziland, they have moved beyond that you cannot stop the registration of an organization. The Kenyans know this. Maleche, don't you know this? The Supreme Court of Kenya said you cannot refuse to register an organization. Botswana has done this. So Uganda is now very backward in that regard. And we've appealed to the Court of Appeal that you cannot stop an organization from registering to protect human rights. So for me, the avenue that we have with the judiciary is very critical and very important. The judiciary nullified the Anti-Homosexuality Act 2014, despite its popularity. Everyone loved the law in 2014. The judiciary said you'd pass this law, you loved it so much that you passed it without quorum. Therefore, the law is null and void. This time around, they are smart. There's no quorum issue. But still have issues around public participation and a number of other issues that we think procedurally should have the law nullified. So for me, the judiciary is such a good avenue because they can't say no, but also if you build your case very well, then they have to hear you. And one thing I want to remind you about the judiciary is one of the buffers in a constitutional democracy. Democracy is about the rule of the majority. So the majority get to decide what they want. But the constitutional court, more especially, the courts have been put in place to fight this tyranny of the majority. The courts are able to say, well, you have your say, you have your way or your say. The majority have their way, but the minorities have their say. The courts are also able to say, we are going to be in line with the Constitution, not just because of what you want or what your values, you think your values are. The values you believe in as a country are the values embedded in the Constitution. So for me, that's what gives us energy every single morning. We wake up and go to court, bring cases before court because we believe the courts have to do the right thing because that's the right thing to do.
Thank you so much. Deborah, I know you talked about fear, and I see it in your face. But beyond the fear, I know there's one famous case in Zimbabwe that we all talk about, Mildred's case. We seem to have many other cases on reproductive justice in Zimbabwe. What do you think we should do differently?
I think what you should do differently is what is it that you want to come out of the case should be determined before you even file your papers. Because I think at times as lawyers also, we are also driven by emotion to say, this is wrong. I want justice out of this. And you are so driven by that that you don't count the repercussions of that case. So we have noted that there are some cases that have been filed, and although they've benefited the individual, they've opened quite a can of worms. So for me, what I want to see is a judgment, yes, that broadens what we currently have, that removes procedural barriers, etc. But I also want it done in a cautious way, knowing that there are some people who are not even aware that abortion is terminated when it comes to abortion. They are not even aware. And by filing a case and putting it out there in the public, we are rousing them we are waking them to that knowledge. And we do know that opposition for sexual and reproductive health rights is quite well organized, well resourced, and well coordinated. And once they get wind of what we are trying to do, then they can mobilize, and we can even erode whatever good things we currently have. So in whatever litigation we are going to do, it has to be done in such a way that it broadens the ground, benefits women on a wider basis, but also protects whatever we have currently gained. And at times I think we tend to come up with judgments that are convenient and not feminist in nature. You look at some judgments and you say, but really this actually makes the lives of the people it was intended to benefit more difficult. And then I think I also want to see a wholesome judgments, wholesome pleadings, wholesome cases that do not just look at a singular aspect. I think I spoke about it earlier on that when it comes to termination of pregnancy, it's actually the end. There are so many failings that would have happened before, and we need to address those before we just rather than just focusing on what in the end we see. So we need to look at broader SR-HR conversations within our country where we are failing, and how we can then address some of those issues. And I think people have spoken a lot around termination of pregnancy, but I think we have had cases of children, of the right to have a child and also the right to register your child. I just want to give an example. I think I spoke to it with some colleagues here. We have certain presumptions that we adopted, like for instance, the presumption of paternity. So it has been presenting some challenges for women who are separated from their husbands. They cannot afford divorce because divorce is expensive. They cannot afford divorce. So in the end, they move on to other relationships. And when they have children from those relationships, when they try to register their children with their new partner, they are not able to do those registrations because our civil registry is super organized. Like the moment they punch in your ID number, they will know everything about you. Your marriage certificates, your divorce orders. The system is integrated even with the courts, that when a court passes your divorce, when your order is granted for divorce, it's sent to civil registry. When you marry, it's sent to civil registry. So the civil registry is really, they actually call it central registry. They actually have, they even used to have even the voters roll there. So they have everything within the central registry. So when the woman approaches the civil registry to register a birth, she cannot, because they say you already have another marriage. And so there's that presumption of paternity that those children belong to your husband. You cannot then introduce a new man. But whereas when you look at men, it's something that they continue to enjoy. They continue to enjoy having other children. So we have not even looked at how do we then rebut the presumption of paternity. So there are so many complex issues that then women encounter. So if we just look at the end stage, we will continue litigating every year as the cases come up. So before we even start litigating, what is the outcome that we want? And if our outcome is broad enough to include all the challenges that women are facing, then for me, I would be more comfortable. Thanks.
Mr. Savabi, in your litigation experience, do you feel that there are any positive narratives that we can all learn as we do our litigations in restrictive environments?
Yes, of course. There are a couple of positive narratives. For starters, strategic litigation helps to shape and guide and development of policy and regulatory issues. You've just alluded to a case earlier on where for example, we also did in 2017, I did a case against Mulago National Referral Hospital at Kawempe and the executive director of Mulago, that was Dr. Baterana then, about a couple that walked in pregnant to deliver, but walked out empty-handed, without a baby, dead or alive. And efforts to get answers from the hospital management were in vain. They were tossed right and left and with no solution at all. So I remember somebody referred them to me. So I was interested in their case. I felt so bad about that level of injustice. I keep telling people that why I went to law school is that I don't want somebody to step my toes and simply walk away. That kind of impunity. At least say sorry, but don't simply walk away. So I like holding people accountable. So I took on the hospital. And one thing I've learned, one other positive narrative I've learned from this practice is that our government institutions are adamant. When you approach them maybe by word of mouth or letters, they are very adamant, they don't want to listen, they don't respond. But when you serve them with the summons to file a defense or applications to file a reply, then they start panicking. So in that case of Mulago, we sued the Attorney General and sued the Executive Director himself in his personal capacity. And guess what happened? The case was cause listed for mediation in the Civil Division of High Court. And that time we saw the entire hospital management headed by the principal hospital administrator, Mr. David Nwamanya. And the whole line of midwives and nurses, about 10 people came for mediation. And the question was, where were you when this couple was looking for the answers about their lost baby? So to me, I felt that yes, we had scored. And indeed, justice was delivered to these people. And out of the discussions, of course, they failed to account for the baby. Most likely the baby was either stolen or sold, nobody knows. But up to now, the body has never surfaced. And there are no records in the mortuary, no records in exit. But at least I was happy that the couple, of course, it was settled by a consent judgment. They agreed to pay, I think they paid 50 million shillings to the couple. Yeah, they paid 50 million to the couple. But at least it was better than nothing, or it was better than having no answers at all for the loss of their baby. So, and we have since learned that the hospital has improved in administration and management of babies. You have also testified to that earlier in the morning, that holding these hospitals accountable, holding these institutions accountable through public interest litigation, we help them improve. The case I was alluding to of COVID-19, the Minister of Health, Dr. Jane Ruth Acheng, said we're sleeping on duty. We actually didn't know that we had an obligation to do this. Yeah, and they constituted a team to draft the rules and regulations for the management and regulation of these hospitals and treatment of pandemics. So yes, there are a couple of positive narratives from these public interest litigation cases.
Thank you. And on that note, usually when you put such public officials, they usually question, even when you go for mediation, why did you put me as a party? And all the negotiation points is remove me from that case. So then we can be able to have a negotiation. So I think...
Actually, if I may come in, that is
very
true.
I will come back to you on that. Tamzai, what do you think are the missed opportunities in litigations in these restrictive environments?
Okay, so the academics have coined something called opportunity structures when it comes to advocacy, and in this case, strategic litigation, in terms of what is it that drives you to litigate? What are the opportunities that are available? What are what we would call, I think this is a cliche, but we all use it, the low-hanging fruit. And I think we at times tend to go for the tough things that will get a conservative judiciary to destroy everything else that you have built over years. When there might be some low-hanging fruit that come from, for example, your legal framework, I would say Zimbabwe, Kenya, South Africa, and a few other countries have enshrined reproductive health in their constitutions. And for me, I think it's an opportunity for us to start from the bottom. What is reproductive health? Because the courts have not been asked to interpret the extent of these rights, right? The extent of what it means when you say that every person has the right to basic health care, including reproductive health. The other issue is the Maputo Protocol is a missed opportunity. A lot of our constitutions as well, either directly or indirectly through the development of jurisprudence, have actually said that international regional law is part of our law. Why? Because the politicians have signed, which means that they have indicated that they intend to be bound by it. Zimbabwe, South Africa, Kenya, others actually have provisions that say you can include international law in terms of interpreting some provisions, right? We have the Maputo Protocol, which, Moses, to make you happy, is an Afrocentric instrument. I will say that, just to say, I don't believe that we are Eurocentric in our approach. because the judges make it difficult for us to be. In my experience, when we are litigating in Zimbabwe, Zambia, wherever, you start local, right? What are the cases that support you, or what is the law that supports you? Then you go regional. What have your neighbors said? To go international is when you have tried all these other things and they are not working. So we are there already. It's just a matter of maybe the theory or the conceptualization. So the missed opportunities here are to continue to do this, to create bigger and better jurisprudence that you can count, you can point at. When you go to the court in Uganda, the judiciary in Uganda probably feels better when it knows that these principles have been looked at by their fellow, their brothers or sisters in Zimbabwe. I can give you an example. The child marriage case in Tanzania, 3/4 of the jurisprudence was made up of the judgment of Malaba J in Zimbabwe. Aren't we proud of that? It was very difficult. The state was arguing that these things are foreign. We have a margin of appreciation that the courts cannot just apply international law just like that without taking into account the local context. And it was pretty clear that the argument was not based on foreign law or Europe or Europeans. It was not our neighbors there, our Pan-African neighbors have actually looked at these things and said, it is in the best interest of the child for this law not to stay. So for me, that's really what I'm saying, where we are lacking. Another example, we have the Disability Convention. This one is a totally missed opportunity for me. All of our countries, with a very few exceptions, are signatories and have ratified the International Covenant on the Rights of Persons with Disabilities. Some have even ratified the optional protocol, but have not seen any major changes in terms of law reform for laws. We were talking about involuntary sterilization. I know for a fact that in Zimbabwe, there is a legal provision that says that relatives of a woman with intellectual or psychosocial disabilities can approach the court and get an order for sterilization, basically because of that. They are, sorry, the convention clearly says you cannot do that. Those are some of the issues that we've not really looked at.
Thank you so much. Do you have any parting shot in just a minute or less?
Okay, so my parting shot is that ideally, you know, we love litigating, we are lawyers, we want to write articles and arguments, but what we always say is litigation should be the last resort, because litigation changes so much in terms of the letter, but at times it doesn't change much in terms of what's on the ground. So litigation becomes the option when all else has failed, or when you are in such an environment where you cannot engage with the legislature, you cannot engage with anyone else, and the courts are the only option that's left, like what Dr. Juko was saying. But in addition to that, it cannot be the only solution. Someone was talking about working in silos. We are all working in different, what can I say, movements. And in this case, when it comes to reproductive justice, I would think that, as Professor Ngwena alluded to, part of the whole reproductive justice paradigm is the creation and the sustenance of grassroots movements.
Thank you.
It's the women who know what their needs are, and they cannot be left out or their spaces be taken over without them being involved.
Thank you. Mr. Sababi, your parting shots.
Parting shots and a confession. For the confession will be the last. For the parting shot, I want to urge my colleagues in this public interest litigation that it really means a lot to add the accounting officers of these respective institutions. If they are the hospitals, it's important to add the management, because last year we did a case of SEHAD and the Federation of Medical Interns and the Uganda Medical Association against Attorney General and Dr. Henry Mwebesa. Because at that time, Dr. Mwebesa had written a letter directing that, requesting all the medical interns who are on strike for necessities to be relieved of their duties and sent back home. And these are the people, when the doctors are busy, it is the medical interns that deliver the women, or who do the rapid response to the expectant mothers or the mothers that are going to deliver. So we filed a case through SEHAD and the FUMI and Uganda Medical Association, and we added Dr. Mwebesa in his personal capacity. And I had a conversation with the lawyer from the Attorney General and said, you can't imagine how this man quarreled when he came to depose an affidavit. He said, look, this was a ministerial position. I was only asked to communicate the decision because I'm the Director General, and now I'm being sued, and moreover in my personal capacity. So it impacted him, it impacted upon him a lot, it tortured him, and he worked hard to ensure that he recalls his own directive. And to us, that was a win, and in fact, it was a quick win for this matter. Then I want to make one confession. Of course, in the desire to be creative and have quick justice, of course, one time we attempted to do forum shopping. And guess which judge we had opted to shop? Absolutely. Clap for Justice Bateva, ladies and gentlemen. Not because he doesn't pay attention to detail, but we appreciate his level of appreciation of these issues, human rights issues. Justice Batema, we thank you so much for standing tall on these issues, and we continue to work with you. That time we had followed him in Mukono. We had yes, I remember he declared jurisdiction. Thank you.
Deborah?
I think just to conclude is that I think what I've learned over the years is just litigation needs a lot of patience, because you might not get the results in the time frame you want, or in the time frame that the donor wants. But I think it requires a lot of patience, and also that every cloud has a silver lining. Even when your case is dismissed, there's a certain case I always go back and read, because the minority decision in that case was then revisited, and it's now part of our law. So just litigating and getting an opinion of judges on that matter is what is also important. So not to worry if your case is dismissed.
Which case is that?
It's an access and a custody issue. Cruz versus Manuel.
Sorry for ambushing you.
No, it's not. So sometimes they will revisit those minority decisions, and or that dissenting judgment was well written, and it's now, so there's lining to every cloud.
Thank you, Dr. Juko.
Thank you. My parting shot is really a nod to Ahaki and the Lira project. The fact that you are able to connect the dots, the fact that you're able to bring people from South Africa, from Uganda, from Malawi, from Nigeria, from Senegal, into the same room to discuss these issues. The issues we face are the same, regardless of our jurisdictions. The forces that we are against are actually global forces that are taking us backwards. This is what happened to Roe versus Wade in the US. The fact there are all sorts of bills in Florida and other places in the US reversing gains that have been made by various movements. So none of us is truly free unless all of us are.
Thank you so much. A second round of applause for my team.
This is quite interesting this afternoon, and I've really liked the discussion. although it has bordered on some aspects which I thought maybe I could mention. One is that I thought the discussion should be, how do we all work together to be able to do what Siri Globen said on ultimate goal of litigation, that is being to address inequalities in power relations in society by reducing the weight of morally irrelevant circumstances. I thought that would be what we should be working towards. And this work should be collaborative. You don't look at the judiciary as being on the other side. You don't look at the AG's office as being on the other side. And I have observed that many times when you talk to people, the lawyers in AG's office, they agree with you. In many aspects, you have had consent judgments and so on and so on. And I'm surprised actually that AHAC did not invite them to be here. And maybe that's why now you have taken advantage and laid strategies of attacking from this side and attacking from that side. Why these attacks? The people we are serving are the same people. So why the attacks? Maybe the attacks are because of lawyers. The lawyers want the attacks. But the people, the victims, may not be in favor of these attacks. Now, yes, you've said that once you file your case, judiciary has no option but to hear you. But I will tell you that recently at Arusha, the East African Court, we told some litigants that don't come here again. Don't file your case in this court. Because he was abusing the court, making statements that, and we said, if you think this bench is so bad, go and look for your own judges. Yes, go and appoint your own, let them hear your case. And now I've heard here about forum shopping. Maybe, I don't know how that is being done, but I hope it was said. So really these strategies, I think, yes, it's good to strategize. I was a litigator for 30 years, and I know that strategies, but the strategies should not be to undermine the essence of access to justice by all. And you mentioned about dismissing cases of technicality. You see, before you begin any contestation, before you go to litigation, the rules of the game are set. If you don't have the rules of the game, then you'll never be able to determine who has succeeded or who has not. And these rules of the game touch on the principle of fair hearing. If you don't have those rules, come at this time, say this, get out at this time, maybe meet these costs, how will you be able to conduct a matter? How will you be able to hear a matter? So these technicalities are also necessary. You call them technicalities, some will call them rules of procedure, and so on and so on. And our Constitution, Article 126 of our Constitution, talks about that. It says the courts should hear substantive justice. It should not take undue regard to technicalities, which is a good provision. But then, and the courts have gone on to say that does not mean that you do away with the rules of procedure. Because if there are no rules, how will you approach the court? How will you approach the court? Now, Professor Mbazira this morning mentioned something. He said he didn't know how the court had awarded damages in petition 16. Up to that time, I think the court was really restrictively interpreting Article 137(4) of the Constitution. That article allows the court to issue declarations and also grant redress. And it says where the court is not able to assess the redress, it can then send the matter back to the High Court to do the assessment. And I know in that matter, the court awarded, I think, 75 million, and 85 million, and 70. And there was a scanty evidence. And you know that the rules or the law is that damages must be proved. Special damages must be pleaded and proved. Now, in Uganda, the Constitutional Court does not hear vis-a-vis evidence. It goes by affidavit evidence. So you put your affidavit evidence in place, you say my client has suffered this, and the petitioner has suffered loss of 70 million. You've not proved it. You've just made a statement in the affidavit. Now, what does the court do? Most cases, they will take it back and say, now go and prove. Go and bring receipts, what it cost you to buy the medicine, transport costs, how much you got in treatment. But I think in that time we looked at it and said, no, we cannot push these people back and forth. What we have before us, and the court has discretion on issue of damages. General damages, the courts have discretion. So I think we interpreted that article more liberally and awarded those amounts. And really, I think this fits in with it, trying to remove some of these impediments, where you look at people and you say, now go and prove. It means getting another lawyer. And yet they have put forth their position. And it's true, they lost some monies. I thought I would just make those comments for this panel to take into account.
Thank you so much, my lord. I don't think you have to leave that place. We are going for a plenary discussion. You have to stay there.
Let the visitor first say something.
Okay, thanks, Prof. I didn't want to make this point, but I'll make it because it came up again in this panel. The one about costs, especially to our colleagues in the civil society organizations. Now, Godfrey, I think, referred to a case which was decided by the Supreme Court in Malawi. The reason why in that particular case, the executive director was condemned in costs was because the ED did not get a resolution from his board that he was taking this matter to court. So it is from that perspective that the court said he was more or less like a busybody, because you cannot take such a serious action without the involvement of your board of directors or board of trustees, whatever the case may be. So before I move to the other side, the last few cases I was doing, I was making sure that we had a body resolution attached to the affidavit as one of the, so that these kind of things are avoided. So that was the context, but I think people can also learn from it. Then, specifically, also on the cases that I did before I moved on the other side, and as what Nimrod was saying, is it Nimrod or Alan about Judge Dingaki and pleadings? The point that I also made yesterday is that on the prayer for costs, I would specifically ask the court not to make any order as to costs. Put it in your pleadings and explain why, because we are a non-profit organization and all these things. So that when the time now comes for the court to make an order for costs, it goes back to the pleading and say, but we were told that, ourselves are not interested in getting costs, and also we can't even, pay costs. So that at least the court is given whatever. So that's one strategy that I used to do. So I don't know whether similar something could be done. Then just to comment on what Dr. Jugo was saying, we also have a case in the Constitutional Court on registration of an NGO going on. We don't know which way it will go. But, one thing that we learned during the presidential elections case in 2020, it was being broadcast on the radio, a number of national radio stations. And the amount of awareness that the public in Malawi now know about court procedures and cases is amazing. It was a turning point, So I don't know whether in other jurisdictions you also have, radios applying to broadcast live cases that are happening in court, big cases. Because, you have translation in the local language, and, you'd find people men gathered with the radio all over the place, people following with keen interest, and in the process also learning. So I don't know whether that can also be a strategy that we can use to bring awareness to, on some of these cases that we are doing. Finally, academics could also help us in, critiquing our judgments and showing us where we're not doing well. And, there are those of us that are willing to learn and, improve. But we can only do so if, you are able, the articles you publish, the books you write, where you show us where we didn't get it right. So I would encourage those of you in the academia, please do critique our judgments and make these articles available to us, and, we'll give you the best. Thank you.
Thank you. I wish to begin with semi-autonomous social fields. That litigation is usually a last resort. That's correct. So where do these litigations begin from? From the family, from the village, from the clan leaders, from the church organizations or mosque organizations. The risk you run is that many of these are not gender responsive. They are not gender sensitive. So much as we may want to involve them or ask them to settle matters on behalf of the parties, they are gender insensitive. We have to be very, very careful as to what evidence we get from them, whether it is oral or affidavits. When we look at some of the affidavits you file, you see like somebody is being either a fundamentalist or is completely ignorant of the current trends in human rights. 2, forum shopping. I think forum shopping is okay. When you want to marry, you present your CV, it is looked at. You can pass or fail the test. It's up to the person you are appealing to. But let me say that the best approach should still remain the human rights approach to development. The word is called PANO. PANO. Participation. I wrote it somewhere. Accountability. Non-discrimination and equity. Empowerment. And legality. We look at panel when we are framing our issues. We look at panel when we are deciding locus standi. For example, the case that was brought to me in Mukono, I was asking, who is the petitioner number 1? To some lady. Said, what are you complaining about? Said, abortion. That the Mukono district government is not allowing us to do abortion. Similarly, the Attorney General and the law. Then I said, excuse me, madam, petition number 1. Did you commit an abortion and you are denied the right? No. Did you attempt an abortion? No. I said, your affidavit is flimsy. You will never win this case along these lines. What is this participation we need from the person who is going to voice so that they appeal to the court? if you have never had any pregnancy, you have never attempted, if you are not a monk, why do you join the dance of tails? So let's be careful and prepare the parties that are going to present the evidence orally or swear affidavits, because they may let us down. Say, where is the cause of action, so to say, technically? Yes, the petition is good, speaking generally about abortion, sexual, reproductive rights, but are you a victim? Are you a survivor? I said, you will not appeal to me. But perhaps, why don't you make me a part and I help you to draft these things better? So go back to that panel. Prepare according to that outline. Accountability. Are you looking for accountability from government or from this particular actor? I like suing the gentleman called Mwevesa, but some people sign 4, and then you are suing them in their individual capacity. He says, no, I signed 4 Batema. Why didn't you sign? Why didn't you sue Batema? I signed 4 permanent secretary. I am not the permanent secretary. You ought to be very, very careful when it comes to accountability. Literally, am I the accounting officer? Am I responsible for this signature? Am I responsible for that office? Or I was holding office? If Nabanja held office for 2 days and the real president is coming back, would you achieve it by suing Nabanja or not? You see? And then this question of equity. It is easier to win along the line of equity than the line of equality. Try it and see if it makes sense. Legality with this pluralism our sister was talking about. People have to choose where to go and what they will get. Look at a case like Mukono University, dismissing all students who got pregnant, and they are above 24 years old. But this is a Christian university. We don't want anybody who has committed, is it adultery or what? Fornication. Go back and bring here a certificate that you delivered the baby. So, excuse me, are you God that I should bring a certificate of delivery? Why not a certificate of abortion? And then they insist that all the lecturers should be married. Didn't the women get bodas and they went with the rings? We know that some people are keeping the rings while others are keeping the men. So look at the wholesome picture and what will appeal to society. And then you go in for this public interest litigation. Thank you.
Mrs. Vatima, if you could repeat for us that last statement. Some people are keeping. Chris, you have a point? Oh, yeah.
Thank you very much. I think mine, 2 points. One is a compliment. I don't know if I got the figures right, but I think it was Dr. Juko who said he has done, did you say 12 cases in 10 years? Okay, yes, and for me, that speaks to strategic litigation, because I think partly there may be other issues, but I think sometimes what leads to being branded as busybodies. So, before I joined the bench, I was in the business of public interest litigation, and those comments never used to go down well with me. But I think partly what brings those comments is, the lackluster and frivolous rush filing of cases where you clearly see, and that's how you end up with things like filing without a resolution, or sometimes without the evidence, or sometimes even missing the point. And in fact, ultimately, at times that ends up hurting the case because you make it, there will be a decision which then makes it res judicata, whereas not. Yet, if you had taken time and maybe coordinated, even coordination, yeah, because if there is an issue and we are very many, even if we want to do a syndicate, but sometimes I think, wanting to be the first or at the forefront or to be seen, and I think that's where that claim comes. But for me, seeing such a number of cases, for example, over that period, it means you're taking time to study the issue, research it, and then file the case. Even the cases we are looking at here from SEHAD, it's not like they're taking every issue every time. No, you take time, you file a case that's watertight, we get a decision, and our people will benefit. Then the second issue maybe is just a point of reflection for all of us. One of the panelists, I'm not sure whether it was this panel or the previous panel, talked about mental health for the people who are hearing the cases or even who are doing the prosecutions. And I was imagining, I had a sister, she passed away, but she was a medic. And so whenever she could return home at times, we would ask, how was it? How was the day? What happened? And then we would be interested in knowing what happened at the hospital. And she'd be like, 5 people died, this number did that. Then after some time, I noticed that she would speak about it very casually. Like 10 people died. For us, we were like, what? For her, it's, like people die every day in the hospital. It's normal. So at first, I thought she had a problem. She was not compassionate or something. But later I realized, actually, as human beings, we have our limitations. If you're very familiar, if something keeps happening before you, after some time, it stops having an impact on how you feel about it. So possibly even in this work, I was trying to put myself in the same shoe and say, if you keep listening to victims over a long period of time, after some time, you may become insensitive. It becomes normal. These things happen. It is usual. It happens. So I think that maybe even as players, because in my public interest litigation, I would be meeting, torture victims, and the beginning, the shock. So when maybe you get a more shocking one, when you get a less shocking one, so maybe we need to continuously reflect, and then maybe now we also need to draw in other people from the social sciences, people in the area of psychosocial support, to counsel us and also tell us what are the impacts and how do you remain emotionally awake and aware of what's happening, such that you don't make mistakes, you remain balanced. Thank you very much.
Thank you. Chris?
Thank you so much. Mine is just a reflection on a concept maybe we tend normally to neglect when it comes to strategic litigation: interprofessional collaboration. It cross-cuts every aspect. I'm saying this because we realized it in 2021 when we had a case in our Supreme Court. It serves as the constitutional court. And I remember we were litigating about task shifting. And then one of the justices was asking, Chris, are you a doctor? I said, no, I'm a lawyer. So how is a lawyer going to explain mifeproston, misoproston, first trimester, second trimester, third trimester, all issues to do with safe abortion? And then you could see that at least they were the court was trying to bring the interprofessional collaboration within one issue at hand. And how do you empower the policymakers? Here, I realize that in constitutional matters, you bring in the Attorney General. For us, it's a different case because Attorney General seems to be an individual. For us, it's government. Then government will sort itself out who is coming, whether someone representing the Ministry of Health or maybe the Ministry of Finance. And then for us, we are looking at the government, and the government position will be clear in the litigation. So I wanted to bring out that one because it is very, very critical, and sometimes we lose it somewhere in the process. The same goes to also the cases of LGBT. When you choose to go to court or maybe use the police advocacy, still they ask you, sometimes provocative questions. Are you a gay? And then you're like, should I answer yes or no? And why? And then they ask you, if you are not, how do you know their rights? Have you lived with them? And sometimes you're like, sometimes it's irrelevant if you look at it in that way. But what they want to show you is that, are these people empowered? The communities you're advocating for, are they part of the process? Can they speak on themselves on their behalf? Can they be able to explain the situations beyond the advocates in court? Thank you.
Thank you. Professor Ben has an issue.
I'll just want 2 minutes. Because when you called Dr. Adrian Juk on stage, the statement you said these issues which are something complex, or I think some statement you made. And this goes to everybody who is here, who is working with us at Ahaki or SEHAD in the context of the Anti-Homosexuality Act and the issues of sexual orientation. For us, in the two organizations, one of the primary objectives is promotion of health and human rights and social justice. So we have come together as boards for the two organizations to become clear that in handling issues of health and human rights and social justice, we are guided by the Constitution and the instruments that Uganda has signed, the Uganda has ratified. And the key principle is equality and non-discrimination. And we say that our Constitution does not say that all people have rights and freedoms except LGBT, Q, A+, etc. And we note that in the struggle for access and utilization of healthcare services, if you do not push for the realization of human rights and freedoms for all, then you are going to frustrate the efforts of engaging all persons, including LGBTI, in a meaningful way. They will be driven underground. So LGBTI people, our position in the two organizations is that they have all rights under the Constitution, within the limits of the law, to enjoy them like every other person. Taking cognizance of the criminalization of sodomy under the penal code. But ours is like those cases of driving out landlords. That is unacceptable. We are landlords, but you don't go knocking on people's doors, whether they are gay, whether they are gay or not. Then finally, again, as organizations, we recognize the fact that what two consenting adults do, whether they're heterosexuals or homosexuals, is none of our business. Our core mission is promotion of health and human rights, reproductive justice, social justice. And we have come out clear. Very soon we are coming out with even concrete statements so that as leaders of the organization, we know that the staff under us are guided in light of this. Thank you.
Thank you, Professor. And I don't think I have to add anything on that. allow me to discharge this panel. It's the longest panel in the history of this Baraza. Thank you so much for sharing, Dr. Juko, Deborah, Mr. Sevavi, and Kamzai. As we clap, we have another panel. We have another panel, but since it's already 5, I think we'll have the panel tomorrow. People seem to be exhausted with whatever they have digested today. So the panel will be happening tomorrow. And in the morning, we'll be able to share with you how the agenda is going to flow. But the panel is deferred to tomorrow. I think now we are free to go and have a break. Is it a health break or evening break? And I've been reminded that some of us have not registered for today. So I've been advised that we pass by Lenny's desk to register. But let's have a hand clap for every one of us. I hope we have a better tomorrow in the Baraza. Today has been very, very interesting. I wish you a blessed evening.